let's start your 7th chapter, people. Relief and Remedies. Relief and Remedies. So, what did we see in previous chapter? What are we going to see in 7th chapter? What is the difference? In the previous chapter, we focused and emphasized more on legal proceedings, meaning when the authority takes action, how the legal proceedings will be conducted, how the penalty aspect will be driven. So completely court was the main focus. In this chapter, we will be only discussing about people compounding under various acts. We will be seeing compounding under Companies Act. We'll be seeing compounding under SEBI. We'll be seeing compounding under CCI, a little part. We'll be seeing compounding under FEMA. So we'll be seeing little of compounding everywhere. And that is how this particular chapter is structured. Clear? If it is feeling suffocating, a little open of the window. I feel it is suffocating. Yes, sir. So, and accordingly, keep it in mind. So, let us first start with the compounding of the Companies Act part. Let us start with what they are telling in Companies Act, how it is, what, everything. Most of it we have already seen also. There is nothing that you guys have to learn something. But interesting, we will see what it is. A new, very good case laws and all are there. We will see how it is seen. Yeah. For example, I'll ask you one question. You guys only try to think with regards to compounding. You guys wouldn't have thought on these grounds till now. Yeah. Let us imagine there is one case, people. There is a case versus. Okay, let us imagine there is a company called as XYZ. This company has done some non-compliance. Now, company on its own filed an application for compounding. The company on its own filed an application for compounding with regards to some aspects. Let us imagine it can be with regards to annual return, non-filing of financial statements, and something and all. They filed an application for compounding. They filed it with whom can we file an application for compounding with? Compounding application under Companies Act. Whom can I file it with? ROC, correct? But what are the concerned authorities? Who will take up compounding? ROC only, no? Of course, in Companies Act, who else will do? ROC only. They added 25 lakh that we saw, no? If you remember, if the amount of compounding value is 25 lakh, more than that will come under NCLT somewhere we saw. You remember or not? So if the compounding authority, let us imagine, is anyone equivalent to the rank of RD. Yeah. So let us imagine we filed a compounding application. It went to RD. Let us imagine. Technically, ROC only will send. But who is, if they're asking you who is a compounding authority, you should write these people's name. It will either RD or any other officer, similar rank of RD, or it will be NCLT, depending upon the value of the offence. So, if at all, let us imagine it's RD. So, we filed an application for compounding. Let us imagine, people, compounding was also done. Now, after 1 year, when they were going through this company statements, they realized, let us imagine this was between 2017 to 2019. This entire thing was what they compounded. They realized, people, who authorities, while ROC was inspecting, ROC realized, people, during this year, there is actually a big non-compliance. What they came and said, we have compounded, but when I looked into it in detail, people, the non-compliance is big. It was not what they actually said, it was actually big. Now, people, ROC or RD, whomsoever you call, they want to revisit the case. They want to reinitiate the proceedings against the company. Compounding is done. Now, the question to you guys is, can I now start the proceedings again where the order was compounded? Can the authority start the proceedings on the company? Is it possible? You guys understood the question, no? Because compounding means what? Compounding means compromising doesn't mean that okay, da macha, it's okay, go off, I'll not say. With regards to the penalty in the section says 10 lakh and 25 crore. I will have to think of so many aspects and when I'll have to come with an amount. Without looking into all of that, how will I arrive at it? So that means yes, ROC or RD has gone through everything. Now let us imagine RD said 10 lakh. But technically now when I am seeing there, you deserve 25 crore. For the offense you have done, can I start prosecution now? Is it possible? I hope you're getting the question. Possible? Because always remember, the authorities are superior. Whether you do compounding or not, when authorities want, they can do and revisit these proceedings when they want. Agreed or not? Answer is no. Because when they filed, when you guys went through, then what were you guys doing? Remember, once an application is compounded, it's an end from the applicant also. It's an end from the authorities also. Eppadi? Nice, no? So they're telling you, authorities, macha, you can't close your eyes and accept some compounding application. It's gone means it's gone. Agreeing? Yes. Why did we say that? Can I go for an appeal on compounding? Now, for example, I accepted every mistake of mine. Minimum penalty is 10 lakh, maximum penalty is 25 crore. The authorities have levied, say for example, 20 lakh as penalty. So I said, why 20? I only came and accepted. Can't you reduce it? I said, no. I can't reduce it. Authority said. Now I want to go for an appeal because I think I deserve 10 lakh. Can I go for an appeal? Is it possible? So when you can't go, I can't go, you also cannot go. Revisiting is that. It's a dead end from both our end. Understood? Oh, pakka na. Yes, sir. Now people, you only tell what is the advantage, what is the need. First of all, what is compounding? Tell me. In your language, what is compounding? It's a settlement. Compounding means settlement. Okay. So what do they say, people? Simple things they have written, nothing that we need to write or know about, whatever we have known till now. Compounding means what, people? It's an voluntary admitting the contravention and pleading guilty and seeking redressal. I am only going and admitting everything, sir. And I'm pleading guilty. Guilty means I'm accepting everything. Please give me some resolution. Yeah. Offences which are not compoundable. Can I compound every type of offense? What are the offenses which cannot be compounded? Two you guys already know. Which one? Only imprisonment, fine and imprisonment. These two we already know. What is the third and fourth one? Third is simple. Investigation has been initiated or pending against the company. What do you mean by investigation? Investigation means what? People, there is a chapter, people, in Companies Act called as Inspection, Inquiry and Investigation. People, nothing but people. You remember SFIO and all that aspect. Sorry, if at all these things have begun, sir, then there is no point in compounding. Why? Macha, already I have come with a matchbox, so I have put it into your ant hill. Now smoke is coming. Now you can't come and say, ayo sir, I am coming and voluntarily I am accepting. No sir. What's the use? We will not accept it. Now my question to you is, people, after looking at this, you guys answer. There is already, let us imagine ROC. ROC has already issued an order of prosecution on the company. ROC has already issued an order that you have not filed so and so returns. I have only found it out. Now can XYZ come and say, ayo sir, yes sir, I accept it. It was miscited. We did not see it, sir. Now I am coming and accepting, sir. Can we compound? So after ROC starting the prosecution, can you go and compound? Is it possible? She was about to say yes, sir. You made her say no. Yes, Kavya, yes or no? She will keep saying, don't listen to her. Go where your heart says. Yes, Mena, she'll keep saying what she wants. You don't get inspired and carry away with that. Tell me. No. Now tell me, can I do it or not? That's why words are important. See, the day our institute goes and questions like these, we have actually seen compounding section also. Section 441. Yeah, people, it can be before or after initiation of proceedings. Sir, investigation is different from initiation of proceedings. Initiation of proceedings is where ROC is saying, sir, there is this part you guys have not filed. Investigation is, people, we doubt something big has happened in your company. Our authorities, inspectors are coming and checking, verifying your documents. If you ask me if there is cancer, stage 1 cancer, curable, that is prosecution. Stage 3 cancer, that is nothing but investigation. You are done. That is what they are saying. Are you getting the point, all of you? See, I mean, I have not even started. I will go there. These are all something that is already there. 441. Yes. So I just wanted to say that is different and this is different. Okay. Fourth one. An offence committed within 3 years from the date on which similar offence committed by company or him was compounded. You guys know this? To question is what I will do. I should not cheat you guys. So I'll first make you guys go through the section and then I'll ask you a question. I know for a fact you will definitely answer. Yes, no, people? Oh, people. Penalties, people. Hey, people, penalties. Hey. I was like, what, sir? Huh? Was it kept human in mind or not, sir, when all this was coming? That's where I said, people, it's okay. We can't do anything. Penalties, if you ask me, overall, people, 1 or 2 questions can come. 3 to 6 marks, people. It's okay. Yeah, you will be at peace because third chapter, penalties are coming. Constant penalties are coming. This is the 3rd chapter. Here will you remember? What, Mana? Mana is like, sir, you're cheating us. I thought you're teaching. You thought you're cheating. Okay. Yes. Repeated offense is different. Tell include me also in the joke. We are 3. In that you make a group. How unfair this society is.
Saying that you asked her whether you guys fought and came separately.
She said yes. Okay, I'll show this to you somewhere. I'll show that to you. I'll first explain some 2, 3, then I'll take you that. Because it is given answer is there only. If I show it off, then you will answer it off. Okay. But okay, understood this one now. Where we will see what is that 4th point. I'll tell this to you. An offence committed within 3 years, I'll tell that particular thing to you. Next ones are constituents of compounding. Meaning what, people? When you are going for compounding, what are the 3 things that will be kept in mind? 3 things is that, people, consciousness of offence, what you have done, agreement not to prosecute, sir, I am coming and agreeing everything, sir. Based on that, now if you start a fresh case, possible, no? I am only coming and giving you of every evidence. Based on that, if you come and file a case on me, if you guys remember in CMSL, you guys would have studied informal guidance, interpretative letter, confidentiality treatment, and what is the 3rd one? In informal guidance CMSL, you would have seen those 3 things under informal guidance. One is confidentiality treatment. One is called interpretative letter. 3rd one you would have seen something. 3rd one is called as no action letter. I am only coming and admitting everything. Sir, you should not take any action against me. Then what is the use of all of this? It's like, people, police is going. I'm coming and telling, sir, I did robbery, sir. I'll give away everything. Don't arrest me. Now, because I only came and admitted, now he got to know and he is filing an FIR against me.
SEBI only can't take action. Other departments can take action. SEBI informal guidance. Other departments can still.
Correct. So, there what happens is, internally, I cannot pass on the information. That is the meaning of no action letter. What do I mean by that? Let us imagine your attendance is monitored by Priyanka ma'am sitting in the reception. She monitors. Everything will be gone and given as a report from Priyanka ma'am to the operations team. Now you will come and tell, sir, I'm not well today, I'll take off. But if it will be counted as absent, sir, I'll try to attend it online. Now Priyanka ma'am would have marked it as absent. So you will ask, sir, I'll ask Mahana to sign, is it okay? So that we can manage. I will say, okay, this is only one last time, Kavya. Because you're regular, I'm giving this option to you. Yes? Now people, but I'll tell one thing. But I will not go and speak to Priyanka ma'am. This is something that is agreed between us. But if the management takes a call, I cannot interfere in between. I don't have a right. Now, if you look at it, me, Priyanka ma'am, operations team, everyone is Arivu. But you are entering into a settlement with one department. I have no control over the other department. That is only called as no action letter. I am agreeing. But if the enforcement department gets to know that you have violated something, if they take an action so moto, I will not poke my nose. But from my end, I've got all the evidence. No, I will not give. That is called as no action letter. Yes, sir. Same thing is happening here. Based on the information I am giving, you should not present that only as an evidence. That is what they are asking for. Yes, sir. Third one, the receipt of penalty. I told you to pay 10 lakh, pay 10 lakh. If you're done, done. That is what is a compounding. Compounding constitutes of these three things. The next one, simple ones, children ones will do of. What are the advantages of compounding? Why should we do compounding? Benefits of compounding. What are the benefits? The first one, acts as a deterrent and prevents commission to offense. What prevents commission of offense? What do you mean by this, people? If at all I go and agree, people, if I agree it in the first space only, the multiplication of offense will always stop. Or else to hide that you will do one more. To hide that you will do one more. So that multiplication of offense will stop someplace. Second one, avoid heavy fines and penalty. Agreed? If I only catch 25 crore, you come. It can be 25 lakh. Yes. Third one, keep the flow of business activity unhindered. Now, court proceedings will start. Your business activities will come for a halt. You will start roaming against some other issue. Why? Concentrate on your business. Just accept some 1 week procedure. Be done with it. Fourth one, help to maintain dignity. I'll tell you one of the biggest thing. Okay. Section 164, 167 of Companies Act. What does it speak about? Very good. Disqualification of director and vacancy. In that you would have seen, people, if I have not filed annual returns or I have not filed financial statements for 3 years, or there are many other grounds given, non-giving of dividends or not filing of, all those things are there. Now let us imagine I have not filed annual returns or financial statements for say 3 years. Yeah, let us imagine. Now somewhere they have said the penalty, or you would have even seen Managing Director chapter. Section 196, 197. In that they would have given, if at all any MD has been made to pay penalty any amount more than 1000 rupees, such person cannot be appointed as a managing director. If at all a person pays any penalty of more than 1000 rupees, if such person has done any non-compliance, if penalty is more than 1000, you cannot appoint such person as a managing director. Now let us imagine this person has done some non-compliance. They have went and compounded. The authority, let us imagine RD told you to pay 10 lakh as compounding application resolution. Now you paid 10 lakh. Companies Act 197 say any person who has paid a penalty of 1000 and more is disqualified from being appointed as a managing director. Now my question to you, now the person has paid 10 lakh rupees under compounding. Is this person disqualified or not? Thousand only is disqualified. 10 lakh here it is. Disqualified or not? Of course disqualified. Answer is no. Why not disqualified? This is the, if you ask me out of this 7 importance, 6 are your BCom answer, 7th one is your actual answer. Remember, very important. What is that, people? You will not be disqualified. Why? Whenever you are taking money, you are paying for the compounding, it is not considered as penalty, it is considered as fees. Whatever is the money you guys are paying under compounding application. Now 10 lakh I pay, no, that 10 lakh rupees will be considered as compounding fees. Whereas what are the words used in the act? The words used in the act will be penalties 1000 rupees. There is difference, lot of difference, and that is why see. So wherever disqualification is tagged with penalty, if you are paying compounding fees, you will not be disqualified. That's the beauty. Macha, this is where your advisory come into picture. You can save a director from being disqualified. At least out of 100 companies, 10 companies will come here only. Are you getting the point? Yes? Okay, next one. Does not burden court with cases. Agreed? Because of compounding, at least those 5 cases, 10 cases are not having to be proven, not going under the trial, nothing. No, I am only coming and agreeing. Then what's the problem? Next one, less time consuming and summary proceedings. That means people, time consuming is less. It will not go to 6 months and all. You agree, you accept, you are done. And summary proceedings. So these are the benefits of compounding of offences. Is clear? So now we understood that, sir, that compounding means we are going and accepting all the mistakes. Now the question is, sir, who will be the compounding authority? Now, if a company or a director of or any of us have done a non-compliance, whom should we go and agree with? We don't know, sir. For that, people, we have a procedure. Now, what is the procedure, sir? We'll take a picture, huh? Huh? Ah. Online now. Aditya, Gayatri, Harshini, Bharati, Srivarsha. Shankar said the day he was going, sir, I will attend every day, sir. Anna Bond didn't even attend after that day. Online and class are. Aditya, what night is going on, a day is going on there? Huh? Yes. Okay. See, procedure for compounding. Filing an application for compounding. Who will file an application? Application can be filed by the company or officer in default. Who is officer in default? If you remember in Companies Act, there is a section also, officer in default. If you guys have studied it, you will know officer in default ka section. Officer in default, section 2, clause 60. Defines officer in default as, for the purpose of any provision, that officer of the company who is in default shall be liable to any penalty, imprisonment, everything. Who will that pay? I hope you guys are understanding what I'm talking about. In every place it is written, Noda, company will be liable for 2 lakh, officer will be liable for 50,000. Who is that officer? Only director, Then CS also is there, Is it? Is it? See here. First one is whole time director. Macha, whole time director is liable. And nowhere it says or and nothing. If they are there, they are liable. That's all. Have you seen this definition? They do not write it as whole time director or whole time director and nothing is written. If they are there, they are liable. That's all. Whole time director, first one. Next one, sir. KMP. Done, no? Who is KMP? CS. See, remember, KMP can be anyone. It can be CEO, managing director, manager, whole-time director, CFO, CEO, CS, one level below the board. But that doesn't mean everyone are there in the company. That's why the third provision here, where there is no KMP, such director or directors as specified by the board. Sir, my company is not coming under KMP requirements. When should I appoint KMP? When is KMP required to be appointed? When? All listed companies, public companies, Paid up capital of 10 crore. Public company having paid up capital of 10 crore or more, KMP will be applicable on them. Sir, what if my capital is 9 crore? So there is no KMP. Yes, there is no KMP. In such case, who will be liable? They are telling you any director who is specified by the board. So one person is authorized to do that particular job. Whoever is authorized, that director will be liable. Sir, what if we have not nominated any director? Aha. If at all you are doing that, then I will make sure, macha, all of you are regretting for it. All the directors will be liable if no specific director is specified. Okay. Fourth one, any person who under the immediate authority of the board or KMP is charged with any responsibility including maintenance, filing, distribution of accounts or records, meaning what people, who is under the immediate authority of the board or any KMP. If you remember even KMP definition people, it says who is KMP? It says that a person who is a whole-time director, manager, managing director, CEO, CFO, CS, and one level below the board, who is designated as KMP. That is what they are telling you. Under the immediate authority of the board. They are nothing but people, functional heads. COO, CRO, CTO. For every department, they are taking that. Now they are eligible. If you guys remember, compliance ownership, compliance reporting, every department will do theirs. So they will take care of that. So they are also considered as officer in default. Correct? No. If someone is doing a non-compliance in the HR department, why should I blame the person in the director department? Whoever is the head who was responsible for that department, he will be liable. Correct? Okay. Next, any person in accordance with whose advice, directions or instructions the board of directors of a company is accustomed to act. Can anyone give me example for this? Any example? Simple example.
Some other manager from another company is giving us instructions.
Why are you following that? Okay. Okay, that also I'll take. Maybe possible. I'll not deny the fact. Okay, I'll take that example only. Now, what she's telling is, people, let us imagine there is a company called XYZ. This company has a subsidiary company called ABC. The directors of XYZ company are telling what to be done to the directors of ABC Limited. Now, they will have to follow it because of the dominance they have, because of the holding subsidiary company relationship. The answer is yes. If ABC company directors are following with whatever XYZ company directors are saying, then they're telling you the XYZ company directors are considered as the officers in default, because I'm just the hand. The brain is yours. So if a non-compliance happened, why should I punish the hands? I will punish the brain. Are you getting the point? Yes, sir. Okay, next one. Every director in respect of a contravention of any of the provision of this act who is aware of such contravention by virtue of receipt of the proceeding on board, meaning there is a board meeting. A, B, C are the directors who participated in the board meeting. There was a matter to be decided. So they took up a resolution. B and C agreed for it. A did not vote at all. He said, I will refrain from voting. I did not say yes, I did not say no. Now, whatever B and C did, it ended up being a non-compliance. A is telling, I will not be liable because I never agreed for this particular resolution. Now, A has come to you as a company secretary for your opinion. Is A liable in this scenario or not? Yes. He's liable. Why? What if I said no? I specifically said no, but majority still went ahead. Now A is liable. In first scenario, he did not vote. In second scenario, he is saying no. Is he still liable? Yes. Why? Okay. Now see what are they telling you? Who is aware of such contravention by virtue of the receipt by him of any proceedings of the board or participation in such proceedings. If I did not vote, I will be liable. If I voted no, I will not be liable. That is what is called as people. I tried stopping, put that effort. Yesterday also when we are seeing, when company is held liable, who are the officers in default? There I told you, if a director can come and prove that it happened without my knowledge. That means what? I never attended the meetings. I was not aware of it. What if board meeting minutes was sent to you? Because before finalization of minutes, it will be sent to you. Now you are aware of it. Did you stop? So all those things will come into picture. So you should have said no somewhere. If you are not saying no, you are coming under officer in default. Are you getting the point? Huh?
Directors are doing, if A is not voting, refrain from voting, how can they do pass a resolution? How will simple majority be achieved?
Simple. No, B and C can go ahead. No, because in a board meeting, you can never have. You thought general meeting. Ah.
I thought B said it. I don't think both said it.
Okay. Yes, Last one, sir. In respect of the issue or transfer of any shares of a company, share transfer agents, registrars, and merchant bankers, it is nothing but people. Few companies manage the share transfer agent job in-house. Few companies outsource it. When any non-compliance is happening in that department where we have outsourced. So let us imagine I am a company called XYZ. I am not able to handle the share transfer job. I will outsource it to some bank. If there's any non-compliance done, people, the bank will take care of it. It is not on me. That is what they're telling. Clear? So all these people are considered as officer in default. Remember it. Yes. Now going back to the chart, what are they telling you? Filing an application for compounding. It can be filed by the company or any of these people who are considered as officers in default. Sir, in which form should I file? I need to file in form people GNL1, general. Yeah, whereas when there is no specific form given people, we generally form GNL1. So we file a compounding application in form GNL1. With whom will we file? Our first point of contact will always be ROC. Now, sir, what will ROC do? ROC will take your comments. If he deems fit, he thinks it's a right application. ROC will forward your application to either tribunal or to RD. Provided, when will he forward it, sir? Provided you have given all the sufficient information. What do you mean by all the sufficient information? These are called the attachments. First one is compounding application, meaning you have filled all the details. Second one, board resolution, because the company is coming and agreeing, right? How will a company agree? The company agreeing is by a resolution passed that we have admitted to go ahead for the compounding. That board resolution has to be submitted. Third one, affidavit verifying the application. Whatever we are telling is truth. We are not making up or hiding any information. Fourth one, general profile of the company, basic nature of the company. Fifth one, memorandum of appearance. What is this? Nothing but, yesterday I told you, wakalatnama. Sir, I am not coming. I am sending our most eligible CS sir. I am sending Mehna. Mehna will come and win the case for us. That is called as memorandum of appearance. The last one, copy of notice received from authorities, if any. What is that? What if prosecution has already started? I can still go ahead for compounding. So if any notice I have received it, give that notice also. That is why if any. You can go for compounding either before initiation of proceedings or even after initiation of proceedings also. So now we have filed an application. Now where is it coming? It is coming to ROC. ROC will forward it to either tribunal or RD. Now people, if you go to your book, your ICSI module, you can see this particular chart. It's there. According to me, this interpretation is wrong. how does the book give? I'll show it to you. You guys only see and say whether what I'm saying is right or wrong. Now, first see what I am saying and then I'll show you the context. Now, what are they telling you people? When you guys are coming for compounding of offences, who can compound the offence people? Our book says if the maximum amount of fine, if it does not exceed 25 lakh rupees, if it does not exceed 25, meaning up to 25 lakh people, I will come to RD or any other officer authorized by central government of that same level. If there's anyone else authorized by central government, I'll go for the compounding of application with RD. If it is up to 25 lakh rupees, if the amount of fine, it is coming to 25 lakh, I'll go here. Sir, what if the amount is exceeding 25 lakh rupees? If the amount is exceeding 25 lakh, where will I go? NCLT, correct? Now, this is the interpretation given in our book. See, maximum amount do not exceed 25 lakh. Maximum amount exceeds 25 lakh. But now look at the Bayer Act. What does our Bayer Act say? The Bayer Act says this. Where can I go? They say I can go to the tribunal or where the maximum amount of fine which may be imposed for such offence does not exceed 25 lakh rupees, then by the RD or any other officer authorized by CG. What is the difference between textbook interpretation and this interpretation? People, for B limit, they have given people that you can go to RD up to 25 lakh. But for tribunal, they have not said any limit at all. Then what do I mean by that? People, you cannot assume beyond 25 lakh is when tribunal should take it up. Sir, what do I mean by that? Because there is no amount prescribed, my interpretation is if at all the amount is coming to 20 lakh, the application can still be taken up either by RD or tribunal. Don't you think so? Because the amount is left blank. Agreed? See, this is a first authority. I am not denying it. But can RD take it up? Answer is yes. I mean, can the tribunal take it up? Answer is yes, because amount is blank. It is not specifically written. So this is an interpretation given by your institute. I'll prove this wrong again. Getting it? Yes, See, this is where interpretation of statutes come. Agreed? Yes. What to do in exam? I'll show you a case law also. Wait. This is okay, Clear, Okay. So forwards, that's why tribunal have not written a limit here. Sir, RD, if amount of fine does not exceed 25 lakh, up to 25 lakh, we'll go there. Okay. The concerned authority would send a notice to company for personal hearing and submission. If at all required, I'll tell you to please come and appear in front of us and accordingly, we will decide the penalty. Is this part clear? Yes, sir. Now see, some questionable points. Now we are calling. There are some, basic points that few people can have a question. So that I have tried to mention you separately. Now what is that? It is a continuation of that only. Try to take off the picture. Hey, you guys are going and writing or what? Or taking print. Do something. Don't leave it. Online, you guys can see this. Clear it is coming. Clear? Okay, now see here. People, some basic questions. What is that? Now, what if in the section people, it is written that the minimum penalty will be 10 lakh. Minimum is 10 lakh. Maximum is written as people, say for example, 25 crore. Now, my question when you're going for compounding, can the compounding authorities go for a penalty higher than what is given in the maximum section that is prescribed? In the section, it is given as 25 crore. In my compounding, can I go beyond the maximum amount? Is it allowed? Can I go beyond 25 crore? Is that possible? That is the question number 1. Can we go beyond maximum? Is this allowed? First of all, tell this answer only. Is it possible? No. Why? Section itself says maximum, sir. If I'm caught also, that is what I need to pay. Now I am only coming and helping everything, and you are saying that I'll levy penalty of more than 25 crore. Am I mad? So people more than maximum not allowed. Okay. Sir, section says minimum is people 10 lakh. Section says minimum is 10 lakh. Now the question is people, can the NCLT order less than 10 lakh? In the section they have written the minimum penalty that has to be prescribed is 10 lakh. I have gone and accepted everything. Can I say don't pay penalty at all? I'll give warning and send. Don't give 1 rupee. Do I have that power? As NCLT or as an RD, do I have that power? Think and answer. Man is coming and telling, sir, first time, sir. First time. So please don't take such stringent action. I did it inadvertently, meaning not wantedly I did. It happened without my knowledge. Please excuse me. NCLT will say, okay, go Mehna. I'm excusing you. I'm saying it's a warning, reprimand, meaning it's a warning. I'll say next time you come, I'll give you a maximum penalty. Can I do that? Is it possible? Is it possible? No. I cannot go less than minimum penalty. That is what you guys think? Okay. Read this case. Taka taka. In case of UW International Training and Education Center, in a suo motu application where in an application for compounding of an offence, punishable under section 56 of the Companies Act, relates to delay in issuing share certificates. If you guys remember, you need to give share certificate within 2 months, 30 days, debenture 6 months, that one. The bench held that the minimum amount of fine specified in the penal clause of the section would apply only when a criminal court is seized of the matter and a compounding authority is not constrained by the said provision. And hence, compounding of an offence could be done even by admonishing the defaulter or by issuing a warning. What do you mean by that, sir? The minimum penalty prescribed there, let us imagine, is 50,000, sir. In this case, they left the people by giving a warning. Admonishing means people warning. Reprimand means people warning. Remember those words. In your exam, if a nuclear bomb will get burst, means people by checking your vocabulary. Admonishing means done. You just have to turn right side and say thank you for giving me this opportunity. Huh? Where will we come and say what is admonishing and all? Yeah. So see, now tell me, is it possible or not? If minimum penalty is 10 lakh, can I go beyond that? Less than that or not? Possible or not? When Kavya and Mehna said it is possible, sir. Book said, please read the second case law also. It is there, no? Okay, now what does second case law say? Read. In case of ROC cum official liquidator versus Gyanchand Agarwal, in relation to an offence falling under section 165 of Companies Act. What is offence under 165? Da? Maximum directorships. A person can be a director of how many companies? Maximum. Maximum is 20 companies. In that also there are subdivisions, if you remember. Public companies cannot be more than 10. Listed companies cannot be more than 7. Independent directors cannot be more than 3. Those things are there. Yeah. Okay. Now in this case, what has happened? A person has become a director more than 20 companies itself. He has done a non-compliance. Okay. And he filed an application in relation to 165 of the Companies Act. The NCLT New Delhi branch has imposed a compounding fee of 10 lakh rupees. Now people, this section has been changed. I don't know if you guys remember. Earlier it said for every continuing day of default, the penalty is how much, people? 5,000 rupees per day. And there was no upper limit at all. I don't know if you guys remember this section. Now it will be striked off. See the last part, 6th one. If a person accepts an appointment as a director, he shall be liable of 5,000 rupees for each day after the first day during which such contravention continues, punishable with fine which shall not be less than 5,000 but which may extend to 25,000 rupees per day during which the contravention continues. What do you mean by that? They're telling you minimum itself can be 5,000 to 25,000. Maximum they have not prescribed at all. Are you getting it? Now, I told you, no, recently we wrote decriminalization of offences. They reduced penalty for a lot of sections. Section 165 is also one amongst that. I'll tell you, this person is biggest reason for this section. Now, what happened in this case? Remember, where did it go? So now understood. Yes, a non-compliance. So NCLT has given a penalty of 10 lakh rupees. Okay. Considering that the applicant had violated the stipulation under section 165 for 849 days. Now, what is given in section 165? Minimum is 5,000 rupees per day. Maximum is 25,000 rupees per day. Now, what happened? In the appeal before NCLAT, the matter went for appeal from NCLT to NCLAT. Now, people look at it. The penalty that is given is people 10 lakh. The authority said, hey, if at all I calculate minimum penalty only, the minimum penalty is 5,000. Can anyone do this? 5,000 into 849. Can anyone do? Online or offline, anyone? 5,000 into 849. 42 lakh 45,000. Devan, minimum penalty is only coming to 42 lakh 45,000. How did you guys agree for 10 lakh for compounding? In this case, NCLAT came and said, see here, preferred by the departments, NCLAT observed that the fine imposed should not be less than 5,000, which can be extended to 25,000 for every day after the first day. Correct? Hello? Now, what did they say? NCLAT observed that the tribunal had to reduce the whatever is the penalty given to less than the minimum prescribed for the offence, and hence NCLAT revised the decision and they made the penalty as Are you getting the point? Sir, in exam now, what do we have to write? In general, I'm telling you people, in general, this is the rule. You can never prescribe a compounding fee less than what is given as minimum. The authorities do not have that power. That is a regular rule. Sir, from exam point of view, do not focus much on this. Because here the biggest thing is it is coming here. This part. This part. Yeah. Which is a very biggest interpretation for us not required, leave it. So when you're focusing on your exam point of view, if they're asking you, quote this case law and you can give an interpretation, not possible. Are you getting it? Now this person had to pay 42 lakh 45,000 rupees. He paid within 45 days. Today people, maximum penalty cannot be more than 2 lakh. If section 165 is violated. Can you see the difference? Decriminalization of offences. Is this part clear, all of you? Any doubt? Pakka? 100%? Yes. Okay. Now see here. Some questionable points. Okay. An application for compounding. When can it be made? It can be made, people, even before institution of prosecution, even after institution of prosecution. If at all you have compounded before institution of prosecution, then people, no person will take up the case going forward. So if at all it is instituted after, people, wherever the cases are going forward, ROC will write an application to all the respective places to put this particular case on halt. So if at all the case has not yet begun, then it will not begin. If the case has already begun, people, then it will come to a halt. Okay. The sum shall not be more than the maximum prescribed. In there, I am also writing it cannot also be less than minimum. Correct? That case law I am giving a reference. The sum, if any, paid as additional fee shall be accounted. What do you mean by that, people? If you guys remember, I have to file my annual return within 60 days. If I don't file within 60 days, what will happen? What is the if I don't pay within 60 days, what will happen? What is the consequence? Minimum fees is 10,000. Additional fees of 100 rupees per day. You have paid that. No, let us imagine you have already paid it for some 30 days. That means you have already paid 3,000. That can be adjusted. That is accounted. Meaning if you have paid any additional fees, that is also similar to compounding only, no? That is what they're telling you. It can be adjusted. Okay. Failure to comply with the order of RD or tribunal, the maximum fine shall be twice the amount provided in the section. So if they have given you 2 lakh, if you do not follow with the order, then the maximum penalty whatever can be prescribed. So annual return maximum penalty is 2 lakh. You need to pay 4 lakh rupees if you fail to comply with the NCLT's compounding order. Is this part clear? Okay. Sir, payment of fees within the prescribed time. In this case, you saw, no, within 45 days you need to pay it. Passing of order by RD or tribunal to the company. We will pass an order. We will send a copy to the company. The company has to forward it to ROC because ROC should know. We will forward it using a form called as INC 28 within 7 days. ROC will take a note of it. This is the whole process of compounding. Any doubts here? Pakka. Now remember, sir, what is that? Sir, when can I go for compounding? Let us imagine, sir, have done a non-compliance in the filing of the form annual return in the year 2016. I have made a non-compliance. Sir, in the year 2017, 2018, again I have not filed the annual return. So what did I do? I went for compounding of offense in the year 2019. I went and I compounded only 2016 ka offense. Whatever I made here, I compounded only this. Sir, now 2017-18 I have not yet compounded. In 2019 I only compounded 2016 ka offense. Now the question is, sir, in 2020, can I file another compounding application for whatever is the offense done in 2017? Can I file one more compounding application for whatever is the offense done in 2018? Can I go for compounding for these offenses in the year 2019? Is the question. Is it allowed? Is it possible? Sir, all the contravention was, people, let us imagine for MGT 7 only. Is it possible? No? Why? Okay, let us imagine in 2016 we went for compounding for MGT 7. In 2017 and 2018 it is for AOC 4. Can I go for it? I hope you guys understood the question. In 2016, I've done a non-compliance in filing AOC 4. MGT 7. I went and I compounded it in the year 2019. In 2017-18, I have not filed AOC 4. Now I want to compound that also. Now I want to file an application in 2020. Will I be allowed? First of all, why I am asking this question, I'll show you the legal provision. Then only you guys answer. Now you see the D point. Keeping this in mind, answer that question.
They have not filed it in due dates.
So can I go for AOC 4? No? Yes or no? Why?
It's not committed after it was committed before. Can you show that?
Sir, no, show that, sir. What, sir? You are confusing us, sir. Ayyo. Only these things came. Tell me. So AOC4 is possible. Correct? So remember people, first rule, try to understand this. Most of the people will go wrong. There are 3 questionable points that can be arrived at here. I have done a compounding of offence. Okay, first of all, I did an offence in 2016. The offence was people non-filing of MGT7. I went and I compounded in the year 2000. When? 2019, I went and I compounded 2016 offence. Now in 2020, can I compound the same offence again? They are telling you people, can I compound? First of all, what was your doubt? Why can it be compounded? Why can't it be compounded? What was the stopping factor? Okay, so remember people, first thing, you guys know, first thing people, MGT7 and AOC4, 2 different offences. Can I take up compounding of another offence? You can easily take it up. There is no problem because the question written is people, you cannot compound any offence which is similar in nature which was recently compounded. Any other offence possible? First interpretation, remember, any other offence, you are free to compound. Every year you can keep on compounding one by one. Absolutely allowed. First interpretation, this is clear. So in 2020, can I compound it for AOC4? Absolutely fine, you can go for it. Because they are not related. Similar offense means what people? Something of a nature which is actually compounded in 2019. If I am repeating the same mistake, I will not excuse you. If it is a different one, yes, go, you are excused. So if it is any other offense people, you can go and compound in 2020 allowed. First interpretation is clear. Okay. Second interpretation, sir. Let us not imagine it is not AOC4. Let us imagine it is MGT7 only that we did not file in 2017 and 18 as well. Now the question is, can I go and compound? Sir, they are telling you people, I cannot go for a compounding of similar offense people up to 3 years. Now the 3 years, from when should I start? Should I start from the day from 2016? I should not commit any other offense in 17, 18, 19. And in 2020, if there is a non-compliance, that can be compounded. Is that the interpretation? Or 2016, I did an offense. It was compounded in the year 2019. The 3 years will start from 2019. So when should I start counting the 3 years? Is it from 2016 or is it from 2019? When should I start counting it? You should start counting it from the day the compounding was made, not from the day the offense was made. So from 2019, the 3 years will start. So you cannot go for a compounding of offense 2019, 2020, 2021, 2022. In 2023, you can again file a compounding of offense. So second thing is people, what? The 3 years is from date of, I wish we will be tested in the same way. Yeah, that is how I want the paper should to come. But okay. Third one, what else? Can I join my applications? What do you mean by that? Can I join an application of 2016, 2017, 2018 at once? And can I file a compounding application? Is it allowed? Or I have to file year wise? Possible? You can always file one joint application consolidating your particular. Consolidating is allowed. Meaning what? Hey, I have not filed MGT7 for 2 years. I cannot take it as one is different, another one is different. You can file a consolidated application. It is allowed. Sir, now the fourth one I have a question, sir. What? Sir, now till now we have seen. Let us imagine annual returns are not filed. Now 2 people are subjected to penalty. Who and all? Sir, one is company, one is directors. Now my question is, sir, can we file an application jointly? Can company and directors together file a joint application? Is it possible? This is called as, people, in legal terminology, we call it as a joinder. Possible, huh? Yes, huh? Now think and answer. Sir, company and directors, everyone's penalty put together, company is coming to 15 lakh. Yes, huh? Okay, company is coming to 15 lakh. Directors' penalty, people, in total is coming to 25 lakh. Total compounding application value is coming to people 40 lakh. The company is coming to your suggestion. Who will be our compounding authority? Is it RT or tribunal? Who will it be? This is clear now, huh? So always remember, when you're taking up the matter of compounding, you should always take it per applicant, not the joinder. So sir, you need to take it as RD as an approval to hear 15 lakh as well as 25 lakh. It will not be considered as 40 lakh.
So many joinder applications.
Joinder application possible, it will go to NCLT. It will always be considered as per applicant. Now you will go to, you can go to RD. It is possible. It is allowed. Understood? Good. Joinder is when you join and you file it. They're telling you should always consider it as per applicant. Now let us imagine, people, there are 8 directors. Every director's penalty is 10 lakh. In total, what is the value, people? 80 lakh. Now technically RD does not have a power. You need to take it as if RD's 25 lakh limit is per applicant. So even though the overall value is 80, but it is, if I don't join it, what will they do? Everyone will file. Technically that is how they need to file. Don't you think nature of offense is same, company is same, default is same? Why should I allow 8 different applications? I can allow them to join and file. When they join and file, people, it is called as joinder. Who will take it up? RD can take it up.
Company's penalty is 26 lakh.
Perfect.
25 lakh.
So perfect. Now people, Mana's doubt is, that was my third scenario, people. If company's penalty, let us imagine, is 30 lakh. If director's penalty is coming to 25 lakh, can we go for joinder? Possible. The answer is yes, sir, but the joinder can be only done with NCLT. Understood? Yes, sir. Now think, people. Sir, company is 30 lakh, officers is 20 lakh. Can I go for a joinder of application? Allowed? Now technically, according to our book, NCLT has a right to, for compounding. They have a right up to what jurisdiction, people? What is the value? More than 25 lakh. Now will this interpretation go good? Answer is no, but this reality is possible. Then how can NCLT take it up? Are you getting the point? So I've tried to give you the scenarios. See here. Sir, will they ask all this? Hey, whenever a student asks this, Noda, I'll feel 2 things. One, you did not understand. Second one, yes, you are thinking that we have gone in depth. Will they question to that level? I don't know in what sense you guys are asking it. I hope you understood. At times I'll always feel, should I go so much in deep or not? Is it good to go or not, Noda? Companies Act means people. Every chapter, man, I will ask. First of all, people, we are doing the 7th chapter, last chapter of your part A. What is the part A weightage? So 7 chapters, 40 marks. Now next, how many more chapters we have? 9 more chapters. For 9 chapters, we get 60 marks. Weightage, you see, 6 chapters, 40 marks, 9 chapters, 60 marks. So if you put all 7 together, the weightage will be less only. Even if you look at volume, you would have covered half the book. After this chapter, half the book will be done. Yeah? So in terms of volume, it is very volume. And in next, at least 2-3 chapters will be connected. Audit. 2-3 chapters will be connected. You'll be studying till here. The next audit will be in the next chapter, something like that. Yes, sir. Yes, people. Now see here. How to quantify the limit of 25 lakhs? In this regard, RD has the jurisdiction to compound an offence which has a maximum fine of rupees 25 lakh. Now the question arises, how to determine this quantum, whether it is per compounding applicant or per applicant. The NCLT has not specifically answered this question, but has reaffirmed the affirmation of NCLT that the quantum of 25 lakhs shall be determined based upon each applicant. So what do you mean by that? It is per director. So I'm talking about the case of 10 lakh into 8. 80 lakh, it can still be taken up by RD. Correct? And is not required to be. This clear? Pakka na? Now see here. So for calculating the monetary jurisdiction, fine shall be calculated on the basis of each application and shall not be aggregated. If in case quantum of fine on company is less than 25 lakh, but more than the set amount for the officer in default, then either a joint application can be filed with tribunal or company can file an application with RD and officer in default with the tribunal. Both are possible. Is this clear?
So if we are filing AOC4 after the time limit, and the next offence is filing MGT7 after the time limit, we are going to compound because this is similar offence.
No, they are different. Similar offences where you commit the same offence again on time. Again, I would say it's an interpretation. What your interpretation is right, answer is yes. It's right. So it's all subjective. Now, if at all the NCLT also is of the same opinion, can it be of the same opinion? If I am at NCLT, I will say it's a similar offence. Similar offence in the nature of not section, in the nature of default. What is default here? Non-filing of form within the required time. Which form? Who cares? Offence is similar, no? I will interpret it that way. But your interpretation is also right. From exam point of view, forms are different. Take it as that way. Real life scenario, that is the way. Because for student level, they not question it that way. Getting the point? Yes, sir. Sir, I didn't understand A and B. Simple, company, let us imagine, if the penalty of the company is coming to less than 25 lakh, but the officers of default, it is coming to more than 25 lakh. Now they have two ways to file an application. One, joint application, file it with tribunal. So it will be 25 lakh for company plus less than 25 lakh for director, allowed. Joint application, you are filing with tribunal. So less than 25 lakh, sorry. So okay, the set amount is more than 25 lakh, sorry. Correct? So see, company is less than 25 lakh, directors is more than 25 lakh. You can combine it and you can file it with tribunal. See, less than 25 lakh is coming not to tribunal. Sir, no, sir, I don't want to go to tribunal. I like RD only. Okay, go. Then file an application. Company can file an application with RD because the penalty is less than 25 lakh and officer will file it with tribunal. Why? Because amount is more than 25 lakh. So you can split and file also is okay. You can file as a jointer application is also okay. Is this part clear? All of you? Okay. This is what I have given you. This is what I explained you. Compounding of repeated offences. Offences committed of similar nature. It's clear all of you. Any second or subsequent offence committed after the expiry of a period of 3 years from the date on which the offence was previously compounded shall be deemed to be the first offence. What do you mean by that? Now 3 years cooling off is done. In the 4th year, I can again go and file a compounding application for again similar natured offence. It will be treated as if it's my first offence. So for every 3 years, you can keep on repeating your mistake. Allowed. Is this clear all of you? That is this section 441. I'll tell you, we have that question also. So the question is, people, what to do in such cases? Let us imagine, sir, we have compounded now only. What if such offense repeats? Now what do I do? If such offense repeats, people always remember. Again, nowhere they write this specifically, but if I have to give it to you in short, whenever an offense happens, people, let us imagine if the offense is something which is only fine related. You have three choices, people, in Companies Act. The choice number one is called as compounding. So if compounding is exhausted, what is the second option? The second option is nothing but, people, adjudication. Adjudication is nothing but, people, wait for ROC to take a step. Whatever we saw in previous chapter. The third thing that can happen, people, is nothing but, what do you call that? The word charge chapter, condonation of delay. What is condonation of delay? You will ask for an excuse. For example, charge chapter. Sir, if I am not able to file the satisfaction of charge within 300 days, I will go and touch the feet of central government. Sir, please, for one last time, excuse me. Central government can give you or allow you to file certain forms even beyond the time prescribed in the act. The third thing is called as condonation of delay. These are the three options you have in total with regards to offences of fine related in nature. Civil offences, you have these three options. It is written in Companies Act, noda, these three. Again, I'm telling you, zoom करके देखो तो ये three चलेगा. Clear? Hello. So remember, have it somewhere so you guys will have an understanding of it.
We are not complying with ROC's order, any of the order, we have to pay twice of the maximum penalty.
Correct, yes.
And yesterday you said if you're not complying with any of the orders, you have to go for civil.
Correct, yes. See, whenever a particular person does not comply with any order, the law says simple. As per the section, whatever is the penalty prescribed, the double of it will be the maximum fine I can go up to in a particular prosecution. That is one thing I can do. Second thing I can do is, what is civil imprisonment? In certain cases, if at all the order of the court is not complied with. Now, for example, adjudication is different, compounding is different. Compounding is where I have tried to come and settle down the dispute. So for that, if you are not doing, I will again levy more penalty only on you. Adjudication is like a prosecution. That means I have conducted hearing. You did not contribute. You did not come and voluntarily, admitted your penalty. I did the prosecution and I levied a penalty. If you don't pay that, that's a serious or a grave offense. So that is where I said you can also be imprisoned. That is where the civil imprisonment can come into picture. So this condonation of delay is considered as grant of immunity. Grant of immunity, the word immunity will not come under Companies Act. It will come under SEBI. That's the only difference. We'll be seeing when we are doing SEBI. SEBI will come. Is this clear? Yes, we'll be seeing about the SEBI part. Okay. This example, remember, whatever is given in 7.15, whatever we saw, I told you that AOC for MJD 7, no? 2019, 2016, this is the example. Yes? Is it allowed? I mean, okay? Okay. People, can you go for an appeal, Ada? Is it possible? On compounding, possible? No. They have given a big scenario, but question is only in one place. This is a question. Is appeal possible? Possible, huh? That is the answer. Correct, huh? Yes, sir. And one case law I told you, the main case law, important actually, that they can question is Vishwanath's case law. Vishwanath's case law. You read this, people. In Vishwanath versus State of Kerala, it was held that once the matter is compounded, neither department nor assessee can challenge the compounding order. Macha, it is a two-way block. You can't let me also do it. You also cannot do it. Department cannot reopen the matter on the reason that actual suppression was much higher. What do you mean by that, people? They realized that after the compounding was made, these people said this is the offense and they compounded it. After 2-3 years, we saw the offense was actually even more serious in nature. Simple. Then what were you doing when you entered into compounding? You should have checked all of that. Compounding is not like you come and surrender and I'll take it. Are you getting the point? Yes. So that is not the issue. That is what they are telling you. It is your duty to go in depth before you say yes or a no.
But after if they find out there is a big problem, who will be liable for that?
See, unfortunately, in government, it doesn't work like that. Who did it? I'll take an action against you. It doesn't work like that. So it's a loss for the government. That's all. You cannot do anything in that aspect.
People bribe the RD and get it settled as well.
Bribe and all is there, right, in the system. I don't know. There, it's there. Isn't it? My God, my goodness. See, I can tell you what is there in the theory. In practical, maybe I can tell you, or may not be also. Yeah, probably certain things we cannot discuss on camera. Yeah, rule is this. Yeah, so when a police catches you, he is levying a penalty of 1,000 and not 100, is what we have to assume. I don't know if it is true. I don't know. I don't think police and all will take this bribe and all. No, sir. Ayo, impossible. Ayo, shant. The Companies Act we saw. Person eligible to make a compounding application we saw. Company and officer in default. Benefits. Which offences cannot be compounded we saw. Which offences cannot be compounded also we saw. Correct? The four things. Any pending investigation or the 3 years. Effect of investigation. If investigation is started, no compounding can be made. Correct? People, effect of investigation, if any, they have tried to give this. See if you guys are able to understand something from here to here. Now clear, huh? Effect of investigation, it seems. Now clear, huh? Able to see, huh? Try to read. Understood something or nothing? Understood something? Is it crystal clear? No, sir. Something and all, they have given lunar eclipse, solar eclipse and all. We are not able to get it, sir. In simple, people have tried to divide that into three different scenarios. Now, what is that scenario, sir? Now, see here. Effect of investigation, if any. I've tried to put it under one and two scenarios. First one, impact of investigation on compounding power. What do you mean by that? RD and NCLT has a power to compound. Agreed? Now, the question is, let us imagine investigation has already begun. Now, compounding application has been filed after the investigation has started. Can we compound it? Investigation is already started. Now the company has filed an application for compounding. Is it possible to compound? No. That is what they have given. The power of RD or NCLT to compound is eclipsed, meaning it is taken away. Correct? That is what is the interpretation number one. When investigation has already started, there cannot be power of compounding. Agreed? The next one, concurrent applications. What do you mean concurrent application? You know, no, you guys, how you will think? What? Sir, compounding also came on same muhurta. Sir, and the investigation also came on same muhurta. Now what will happen, sir? Both applications same. Ange, sir, I opened the door, both applications just came and hit me. Now what will happen? Whether compounding will go through or investigation will go through. So second thing they're telling you people, investigation is much more superior. When a simultaneous application scenario comes into picture, investigation still overrules. Understood? Okay. Third one, apprehension versus actual investigation. What do you mean apprehension? Meaning we are thinking to investigate. We are not started. Versus compounding. So thought of investigation versus compounding. Which one will prevail? Thought versus compounding. Which one will prevail? Compounding. Apprehension means people, nothing solid yet. Understood? So three scenarios. That is what they have given in this complicatedly. Is this clear? There. The compounding authority may, on merits, not agree to permit the compounding as the power of compounding authority under section 441 is discretionary. Now, what do you mean by this, people? Okay, I'll try to explain you one scenario. ABC files an application for compounding with, let us imagine, RD. RD rejects the application. Is this valid, invalid? Valid? Why? They have the authority, they have the discretionary power to reject the compounding application. Is this clear, Agreed, As you rightly said, people, this cannot be rejected. Why? People remember, merits here, you do not have a power to reject the application. You have a power to reject the compounding. Difference iruka, iruku. Illa sir, did not understand. You do not have the power to reject the application. You have the power to reject the compounding. What do you mean by that? Merits means people, allow them inside. Opportunity of being heard. You cannot reject the application in the stage itself. Take it up and reject. Hello? Clear? Is this clear, all of you? See, examples of compounding. Failure to maintain register of companies, register of members and all that. Failure to hold AGM. Failure to maintain statutory registers. Compounding can be done either. Clear? Okay, compounding authorities. Now people, list of offences. From my end I can say, try. Yeah, because they have given 3 offences, people, not also only this. How they have given is, what are the offences that can be compounded by RD? What are the offences that can be compounded by tribunal? Why? Because in each of the section, the penalties are different. And the power of RD will be allowed up to 25 lakh. Power of tribunal will be about 25 lakh, he can take it up. So they will give you. I'll not cheat you also. They have given in one illustration, one type of question. I should show that also so that you know this type of question is possible. Are the following offences compoundable? And if yes, meaning what, people? If I have to write RD, if I have to write tribunal, I need to know the penalty. So, tribunal has a power to take up both. Exam point of view, you need to write specifically up to 25 lakh. It will go to RD. Practically, yes, tribunal can take both. That's why I'm telling you from exam point of view. Yeah, fraudulently issuing duplicate share certificates. That's the thing. So see, they are telling you fraudulently issuing. Since the offence is punishable under section 46(5) with fine only, it is compoundable by under section 400 by RD or NCLT. Failure to keep proper books of accounts, it is compoundable by RD. Why here RD or NCLT? Why here RD? Because people, in an offence, they would have written offence is punishable either this much or 3 times the profit made, whichever is higher. Imagine people, the profit made is, let us imagine 5 lakh. 3 times the profit made is how much, people? 15 lakh. So it is coming with RD only, no? What if the profit I made is 10 lakh? What is 3 times the profit made? 30 lakh. So this section can come with RD also, NCLT also.
We should consider the maximum fine.
Correct. So I'm saying, let us imagine the maximum fine is 1 lakh or 5 lakh or whatever is the profits made, 3 times of the profits made, whichever is higher. So my profit made is 5 lakh rupees. 3 times of the profit made is 15 lakh rupees. Higher is 15 lakh. So the maximum penalty I can go up to is 15 lakh only. So RD has a power. What if in another company scenario, they made a profit of 10 lakh? What is that 3 times of the profit? 30 lakh. Now can RD take up that application? No. But technically that section can come under RD also, NCLT also. That is why they have given here as that. Man is like, sir, okay. Okay, I understood. You don't have to again tell detail, I understood. Clear? This is nothing but, people, that question of the 3 years. Can we take up a compounding of offence within 3 years? Answer is no. Company cannot go for compounding for non-filing of return of allotment. Clear? Now they have asked, what if compounding is not there? What can I do? However, there is no such restriction imposed under section 454 on adjudication. They can go for adjudication. And also, what are the options available? Adjudication, condonation, or compounding. We have all 3. Correct? Can we challenge compounding order? No. Procedure for compounding of offence, whatever we saw. First you file with ROC will file it with the application, no, NCLT RD, INC 28 or 7 days, done. Correct? Is there any discretionary power to reject the application? Can we reject the application? No. You can reject compounding. You cannot reject the application. Very big differences there. Yes, this is clear. The money, whatever is the compounding money, it should be paid to the central government's account. Only after remittance of the sum specified by the compounding authority can it be said that offence in question has been compounded. Only after paying of the money, we will say that the money is compounded. The first provision specifies that the sum so specified shall not in any case exceed the maximum amount of fine, which we already seen. Yeah. The amount should be determined after duly taking into account any additional fees. I told you we can set off. Penalty for non-compliance of order, I can always take double the thing, correct? The maximum amount of the offence for be shall be twice. So this is what is under Companies Act. Is clear all of you? Okay. Go for a break and come. We will continue with SEBI after the break. Okay, done. So now people, we have done as per Companies Act. Now what is left is people, SEBI is left, a little one paragraph of CCI is left, and they have also given FEMA. FEMA is left. Yeah. Of course, SEBI forms the predominant aspect out of what is left. And of course, FEMA also they have given in detail. Literally, they have given in detail. See, this is that's all is Competition Act. Yeah, and they have also given FEMA. FEMA also they have given good 15-16 chapters of explanation. And last one is mediation and conciliation. The last part, which you guys have. Okay, no. Open book people, you will have a little reference here. So that is your chapter. So we'll have SEBI, we'll have Competition Act, we'll have FEMA. FEMA little, I mean little lengthy only. They've given in depth of compounding and all that. And we have mediation and conciliation. Mediation and conciliation is a little in detail. Yeah. But let us see. So let us start with the SEBI. To understand SEBI, sir, I have again made a chart for that so that you guys can understand the SEBI part. Okay. Composition of offences in SEBI. Now in SEBI, what do they say? She's coming up. I'll wait for a minute. Okay, because it's setting the tone, she shouldn't miss. Okay.
So corporate finance will get all of 19 days.
Yes. Now drafting is pending, corporate restructuring a little is pending, SM is pending, correct? That's all, right? Max by November end, you will be done with everything. Yeah. I think mine a little portions will be pending. We will see how do we do it. Yes, sir. Okay. Now what we are seeing is people compounding. We are starting with the compounding under SEBI Act. Now what have they given? How does it happen? What is the provision and all that people? I have given you a procedure. Yeah. Before I do this, what I thought was, if we see this particular chart, people, it will almost give us clarity on a lot of aspect. So what I have tried to do is I've tried to, okay, if you guys can take a picture of this, is it clear? Yes, online? Online, see if this is clear. Take a picture. Please share it in the group also. Or I'll write one more thing. After that, if you want, you can take it. 1 second, wait. Yeah. Here, try to read along with this regulation 3. And here, let us write here the board will come. That is nothing but SEBI. In addition to that, there are 2 more regulations. Regulation 5, regulation 6. Read those regulations here so that it will make sense for you. In applicant, read regulation 4. If we read it in this connected way, it will be easy. When we are reading note, read regulation 7. And when you are reading settlement terms, here read regulation 9, 10. Yeah, and the other 10 part. Okay. Okay. Now try to take a picture. Will it be visible? Regulations and all still? Is it still visible? Regulation 3, 5, 6, 4, 7, 9, 10. Online, I think you guys should be able to take it better. Online, let me know once it is done. Huh? Clear? Yes, da? Yes? Okay. Okay, done. So, sir, composition of certain offences. Now, what do we have here? Okay, there is something called as compounded. Okay. Next one, people, is settlement. And for settlement, they have given okay. Now, write down one chart, people. I don't think I've given here. Okay, write down one chart. This is only for our understanding. They have given something called as compounding. They have also given something called as, people, settlement of administrative and civil proceedings. Settlement of administrative or civil proceedings. Or civil proceedings. This is given in section 24A. When you guys are trying to read this, try to read it this way. This is given in section 15JB. Here, power to compound power to compound is with the Securities Appellate Tribunal or a court where proceedings are going just give me 1 second. Yes, sir. Third one, people. Okay, here it is. Who is doing it here? It is done by SEBI. Even in, to be very specific, yesterday we also saw the enforcement department, which has 3 divisions and all that we saw. Here, people, this is basically the criminal actions are compromised. Basically, I'm speaking about those actions which need prosecution and liable for fine or imprisonment. Whereas in this case, it is only administrative or civil. Administrative or civil. Administrative or civil. Fourth one, the compounding order does not enjoy confidentiality. The compounding order does not enjoy confidentiality. The consent order may or may not include a determination that violation has occurred. Okay. Copied. So in SEBI, what they have done, people, they have tried to give you 2 things. One, people, is called as compounding. Next one, they have tried to give something called as settlement of administrative or civil proceedings. In SEBI, the maximum it goes on, people, will be here only. Yeah, in the SAT cases and all, very rarely we come across a scenario where the compounding happens. But in short, to keep it this way, what is the difference? Settlement of administrative or civil proceedings, if you remember in the last chapter only we saw, where SEBI only suo moto or the applicant will come and enter into a compromise with the level SEBI is doing. It can be civil proceedings. It can be with regards to, imagine you had to apply for some license, you have not applied. You have to do certain things within certain days, you have not done it. Now those things can be compromised with SEBI directly. You need not have to go to any court or any tribunal. Whereas on the other case, people, there is a prosecution that is happening. Imagine it can be a criminal offense. The words used are not penalty. The words used are fine. That means it will not be taken up by our regulatory bodies. It will be taken up by the courts. Now, such cases, people, SEBI will not have a say in it. You need to go with something called as compounding. That is what they're telling you. When a SAT or any court has taken up a matter where fine is involved, not imprisonment, I'm talking about fine. I'm not even talking about penalty, I'm talking about fine. I told you the difference between penalty and fine. So when fine is involved, people, now if I want to go and compound that offense, I can go and compound it in front of Securities Appellate Tribunal, or if any other special court has taken up the matter. Now what is special court? Those courts created for speedy disposal of offences with the approval of central government. If they are taking up any of those matters, then people, you can enter into a compounding with the SAT or the special court. Sir, and remember, one of the main differences this, sir, what is that? The compounding order does not enjoy confidentiality. Confidentiality means what, people? Now imagine I go and accept all my mistakes in front of Securities Appellate Tribunal. Securities Appellate Tribunal will issue a compounding order. In that it will be written that the said complainant has violated the section from this section to this section, and as a compounding of offence, that means we are settling this, compromising, and hence the person is required to pay a fees of around 12,50,000. Everything will be in detail explained, and that particular document will be available in public domain. Meaning what, people? Damage directly or indirectly will happen, because what you have violated will be written, but we will not call it as a fine, we will call it as fees. But fees for what? For violation, that will be written. Reputational damage here and there will be there. Whereas in the case of confidentiality treatment, in the case of administrative or civil proceedings, it is literal secret between you and me. The world might know you have paid some fees, but that can be any fees, world will not know. And that is what is called as, people, when SEBI agrees with the settlement, you can also request for a confidentiality treatment. It is absolute discretion. SEBI may give you the confidentiality treatment. If it is given, people, consent may order may or may not include a determination that violation has occurred. Meaning it will have or it will not have. World may know, world will not know. Understood? So these are some basic differences between compounding or settlement. Because they have given, that's why I thought of writing it. Clear, all of you? Okay. Now, sir, how does this particular compounding happens? Nothing is given. Compounding is as SAT takes it up or any special court takes it up, you go and settle the matter directly with them. We do not have much in detail with regards to that. But now whatever we are going to discuss, people, further will be completely with regards to the settlement. Now how does the settlement happen? Now see here, the settlement happens in this way. How? The procedure of settlement. Applicant on default. Default has happened. Whether it can be before initiation or after initiation. Correct? That we have seen. Sir, so whether it is before initiation or after initiation, now when it is before initiation, people, we need to read something called as Regulation 3, it seems. Now what does Regulation 3 say? Regulation 3 says, okay, Regulation 3 says this, what? Application for settlement. We are filing it now. Okay. A person against whom any specified proceedings have been initiated and are pending or may be initiated may make an application to the board. We are filing, to the board. We are filing to the board. Correct? Okay, we are filing an application. Board here is, people, SEBI. In the form specified, that not required for us. The application made above shall be accompanied by a non-refundable application fees. There will be fees involved. You need to pay that. It cannot be refunded. Okay. The applicant shall make a full and true disclosure in the application in respect of the alleged default. Whatever is a non-compliance I have made, I have to disclose everything. Okay. Sir, provided that the facts established against the applicant or admitted in any ongoing or concluded proceedings in India or outside India with respect to the same cause of action under any law shall be deemed to be admitted by the applicant in respect to the proceedings proposed to be settled. What do you mean by that? I should also clearly admit, sir, when I am filing this, there is a simultaneous case going on in UK court. There is a simultaneous case going on in this court which is related to the same subject matter. I have to admit that as well when I am filing an application with board. Okay. The applicant shall make one application for settlement of all the proceedings that have been initiated or may be initiated in respect of same cause of action. Meaning what? I have done the same non-compliance in 2016, 17, 18. I can file a consolidated application. One application is sufficient. Okay. An application that is not complete in all respects or does not conform to the requirements of these regulations shall be returned to the applicant. If you have not completely filled it, they will give it back to you for filling it again, sending it back. The applicant whose application has been returned may within 15 days from the date of communication submit the complete and revised application. I'll give it back to you. 15 days you need to resubmit it. Where the applicant is in association or a firm or a body corporate or a LLP, the application and undertakings and waiver shall be executed by a person in charge and responsible for conduct of the business. What do you mean by that? If it's a human, he will only sign. If it's a LLP, if it's a company, the person in charge shall sign. It can be directors, it can be any other person authorized by the board, they will sign. They will be the person who will take this forward. Yeah. An application for settlement of defaults related to disclosure shall to the extent possible be made after the required disclosure. So we are seeing how to make an application, what all to be disclosed, who is the person who will lead the application. If there is any defects, we will file it back, rectify it and again file it within 15 days. Simple procedural is what is given in regulation 3. But this is clear all of you? Okay. If you read it this way is when you will understand. Getting it? Okay. Sir, after initiation of proceedings, meaning already they have started the proceedings against me by the board. SEBI has already started it. Now what to do? A show cause notice has been issued to me, meaning SEBI itself has thought, hey, there is these proceedings you guys have violated. You tell me why should I not take any action against you? You show me the cause. From the day I get the show cause notice or from the day I get a supplementary notice. What do you mean by supplementary notice? Here I have given you some basic information and within next 1 week I have given further more information on the same document. Now the thing is, within how many days should I file the settlement application? Because even after the SEBI has initiated proceedings, I can still go for settlement. Now the days will start from when? I need to go within 60 days. That is clear. 60 days from getting the first application or 60 days from getting the supplementary. They're telling you whichever is later. The 60 days will start from whichever is later. Okay. So I got, they have taken an action. They have started. Now I can go and ask for settlement. Okay. They're telling me to read regulation 4 here. What does regulation 4 say? It says limitations. Nothing but people that whichever is later, 60 days is given there. This is only regulation 4. Clear? Okay. Regulation 4 is done. Okay. Done. Next one, sir. Once we file, an applicant is filing it. Now what will happen? The entire thing will go to internal committee. Now people try to understand this. Now whenever we are filing a settlement of administrative or civil proceedings, now we are filing it with SEBI. But inside SEBI, who will work on this settlement proceedings and all? They have not given us in detail. But for us to understand, I've given something called as a breakup. Now let us try to understand that. That is only called people regulation 5 and 6. Now what does regulation 5 say? Now try to concentrate on this. Scope of settlement of proceedings. Now what does regulation 5 say? We are filing an application, correct? Okay, now see here. We are filing an application. Now they're telling you 3 scenarios. Keep these in mind when you guys are filing an application. Meaning what? Certain scenarios where application will not be entertained. Certain scenarios where application will be rejected. So when settlement is possible, when settlement is not possible, it is given in Regulation 5. That is only called as scope of settlement. Regulation 5. Read this. No application for settlement should be considered when if earlier application with same default was rejected. You filed. We clearly said because of these grounds, we are rejecting it. Again, the same thing will not be entertained. Second one, audit, inspection, inquiry, investigation is not complete. Prosecution is different. Investigation is different. Investigation is started. No settlement is possible. Third one, money is due under order issued under security law. What do you mean by that, people? There is already some order issued to you. You guys had to pay certain fees, fine, penalty to the company, to the SEBI that has not been filed. Then people, you will not get a right for settlement. It will be rejected. This is clear? Okay. Second one, board may not settle if it is of the opinion that, so I have taken up the application, I am going through it, but I will not agree for the settlement. When I'm thinking, SEBI is thinking that if at all I settle this, whatever the default you have made, this has some wider impact. I cannot settle it here. I need to take it deeper. Now that is what they're telling you. The board may not settle if it is of the opinion that the default has a market wide impact. If I settle this, people, it will not be right. Second one, you have caused loss to the large number of investors. Third one, you have affected the integrity of the market. Then people, settlement is not the right word. I need to literally criminally prosecute you. There might be imprisonment also involved. So it is not right for me to settle this. Yes, sir. The third one, sir, what they're telling you, for settlement any proceeding, board may consider the following factors. Now, if you have to take up the matter, here we are speaking about rejection. If you have to accept your application, then the board will consider the following matters. What is that? For settling any proceeding, board may consider the following factors. What is that? Has the applicant refunded or disgorged the money due? Meaning what, people? Whatever is the application I'm filing, I'm saying that I want to, for example, I'll tell you, people, let us imagine, okay, now sitting inside the class, people, what I'll tell you, guys, you guys give me 5,000 rupees per month. I will tell you which and all are the stocks you guys have to invest. I'm taking money from all of you and I've started giving calls for your trade. Now, whatever I've done, is it valid or invalid? The first thing, people, for doing this job, you need to be registered with SEBI under a category called as what, people? Research analyst or investment advisor. Only SEBI registered intermediaries can continue giving such, what do you say, whatever these things are, these services are. Not a random person can undertake it. For example, you guys will be seeing in YouTube and Instagram, no, we have so many people who will come and say how to plan your finances. For example, Rachana, recently one person became very popular, Finance with Sharan. Very, very popular, they are all becoming. All they are having what, 3 million, 5 million, 10 million, 20 million followers and all. Rachana, you have not seen? We should have typed, no, sir, for them to come. Someday in our life, we should have typed. If we type, they will come. See, our complete things will be this only. What? Which movie? Kantara is released, that only will be there. Rachana Ranade. See. Yeah? Yesterday, someone was asking, sir, how do we, do it? Yeah? Now see, she's telling LG IPO. IPO good. And she has put question mark. Can you see the thumbnail and all? Now is it all good? Can they do such things? Can they give Tata Capital IPO? Can they do this? People were doing. Don't you think they can influence? Now see people, I'll tell you one thing. Okay, let us imagine this Dasara gold, buy or sell. Can you see that? Yeah, because talk of the town, gold and silver, every day hitting new targets. Gold is so crazily going up. Crazily going up. Yeah. So now she is telling buy gold. How many people have seen it? 114K. In that, let us imagine 10% of the people gets influenced. Don't you think this lady is controlling the capital market? Now, if you look at it, SEBI laws, it does not have such people in SEBI registration at all. When SEBI laws was made, who thought on Instagram, on YouTube, someone can come and influence the market? So SEBI created a new registration for these people. Now they are termed as finfluencers. Now there is a specific code of conduct that is written by SEBI on how these people should act, apprehend. And you are made liable. Don't you think they are able to control the stock market? Yes, they are. Getting a fair point of what I am saying. So it can be influenced. All these people can be possible. Now let us imagine, sir, one person started giving all the calls. Meaning people invest in this, invest in that, it is good. Have I taken registration? Answer is no. SEBI got to know that I am doing this. Mahana went and complained. Now SEBI issued an order to me. Hey, I heard that you are giving calls and all that by taking money. Is it true? I am caught. Because I have all transactions, all people sending money, I have messages and all. So I cannot escape, I know. What is it I can do? Sir, yes, I did. So I have to file people settlement with SEBI. Sir, I have done, sir, I have agreed. Now what will SEBI say? SEBI will not leave me. First thing they will say, they'll pass as disgorgement order. You have taken that 5,000 rupees and all, no, first to refund that. Now whatever I have taken, when the non-compliance started, entire money after refund. So you can imagine, probably I would have made my living based upon that. This, yes, disgorgement order never will the authorities take. Disgorgement order is always for the people. But it will not be possible for me to give it to the people directly. So the authorities will take, they will ask the list of settlers from you and they will disgorge the money. Understood? Now you would have made some profit out of it. That the authorities will take. That will not be given to the investors. Getting the point? Okay, now the disgorgement order. Now people, SEBI will say, I will levy some penalty. You pay this much amount, then okay, we can settle it. Now this is only called as people administrative and settlement of administrative or civil proceedings. Now see what they have given. For settling any proceeding, board may consider the following factors. What is that? Has the applicant refunded or disgorged the money is due? Next one, has the applicant provided exit option to the investors? Now I would have taken, you guys are all still with me. First to settle off everything. Don't have a carry forward thing. Next one, is the applicant compliant with security laws? All the other things are you complying? This is okay. Rest of it and any other factors I will consider before I'll pass a settlement order. Yeah. Next one, board may not settle if applicant is a willful defaulter. Next one, fugitive economic offender has defaulted payment of fees, penalty imposed under security laws. Earlier I have told you to pay, you have not paid. Then such people will not be entertained for settlement of administrative or civil proceedings. Clear? So what's the difference between willful defaulter and fugitive economic offender? Willful defaulter is a person who, in spite of having money, has not repaid it. Fugitive economic offender. Fugitive means people nothing but a person who has left the country for anything with regards to the economic offences. A person who is not available, who is ran from the country, we call him as fugitive. Vijay Mallya comes under both. But now no longer willful defaulter because he claims that he has made all the settlements. So we call him now only as fugitive economic offender. Nirav Modi, Lalit Modi and all these people are all coming under the same category. Clear? All of you? Okay. Now, sir, we understood Regulation 5. What does Regulation 6 say? Regulation 6 says rejection of application. These grounds we can reject the application itself. What does that say here? An application may also at any time be rejected on the following grounds. At any time it can be rejected on these grounds itself. What is that? Where the applicant refuses to receive or respond to the communications. I started it, but I am not continuing it. I can reject it. Where the applicant does not submit or delays the submission of information, sir, another 3 months, sir, another 5 months, I'll give it to you. I'm not going ahead with the pace of settlement. Yeah. Third one, I told you, right, that Sahara dispute. In Sahara case, what happened? Uh, in Sahara case, in short, I'll tell you, there was a company called as Sahara. Sahara wanted to go for IPO. They filed their prospectus with the SEBI. Sahara has a list of subsidiary companies like this, you can imagine. Somewhere here there was a problem. Now, what did this company do? This company was not a listed company, but they had done a private placement with a 2.5 crore people. It's an unlisted company. If you're an unlisted company, the maximum private placement you can do is not more than 200 per security in a year. Even if you do 200, they have done non-convertible debentures. Macha, how many years you should have done to issue 2.5 crore applicants? So everything started, it was a clear violation. SEBI said, okay, it's no longer, this is not possible, you have violated it clearly. First you need to refund the money. Second thing is that, first you give us, because refund, if I tell you, you will say, yes sir, I have refunded. Now what is the guarantee? So SEBI always say, do one thing, give me the list of people and send us the money. Sahara said, we would need 2 years to give you the list of names. SEBI said, are you mad? It is a one document wherever you would have said you need to give it that particular document. Why 2 years and all? You need to give me this entire list by 30 days. So Sahara tried to give it 30 days. It was not possible. SEBI gave, I'll give you one last extension. Within the next 30 days, you need to submit it. If not, I'll issue one, order against you. This cannot go healthy. So people, Sahara, in the next 30 days, people, they gave the information of around 7.5 lakh people. SEBI issued 2 things there. What? Why 7.5 lakh? Where is 2.5 crore? Where is 7.5 lakh? Now one thing is clear. What? You're creating the information as we are speaking. That's why you're not able to generate the names of 2.5 crore people. Second thing, people, now the doubts started on who these 2.5 crore people are. So what did SEBI do? SEBI randomly started doing audit. Meaning they will take up the details of 100th person and they will check who is. They will try to contact. First thing, they have not given any IDs of these people. So now they will randomly call. They will randomly go to that person and they will try to investigate. It so happened, people, SEBI did the audit with some 22 applicants. All 22 applicants were bogus. It did not exist. They were all created, made up. So what started with the non-compliance of private placement ended up becoming an issue of money laundering. So Prevention of Money Laundering Act started coming into the picture. And ended up being Subrata Roy being arrested. One of the very reputed companies went for a toss. Today Sahara literally no longer exists. There is a very big myth. Simply casual fun facts they will keep telling. No, there is a very big myth that whoever are the companies that sponsor Indian cricket team, that they all end up in such scenarios. There's a very big myth. The first company that sponsored was Sahara. Sahara went. The next company that did was Paytm. Paytm got screwed up. Next did was Byju's. Byju's so literally screwed up. Dream11 recently filed their winding up liquidation is going on. Every company that has come, it's a simple myth they say, but nothing to do with Indian cricket team. I'm just sharing fun fact. Don't file a case against me. Yes, understood. So that is what they're trying to tell you here. See here. Does not submit or delays the submission of information. This part clear, I've asked you to. Yes. Where the applicant who is required to appear does not appear before the internal committee. I'll tell you who is internal committee. Where the applicant violates in any manner the undertaking and waivers as provided in Part C, meaning I have clearly told you whatever the undertakings you have to do, you have not done it. Where the applicant does not remit the settlement amount within the prescribed time, again I'll reject. Where the applicant fails to comply with the condition precedent for settlement within the time as required by internal committee, meaning I said, see, for me to accept this, you have to first to satisfy all the above things. What? Disgorgement, exit the positions, give away whatever is the commitments you have made. You first to settle all of that, then come. If you are not satisfying that, then settlement is not possible. If you have not satisfied, I'll reject it. Yeah. Whatever is a rejection, it will be communicated to the applicant. This part is clear where rejections is happening. Okay. Now, sir, what they're telling you people is, we saw something called as internal committee. Now, it is not anywhere written in our book, but for us to understand, remember, we are filing people the settlement application with the SEBI. Sir, please excuse us. We have done this. Please excuse us. Now, do you think SEBI literally undertakes everything on its own? SEBI has a division, department people called as ED. Now, under ED people, for us, face of it only ED works. But behind ED people, there are three hierarchies. And the three hierarchies are called as people this. Committees involved in settlement. Is it required for us so much in detail? No. But we need to know how this functions. That is why I have tried to give you. You first understand this and then you will understand the names coming in the settlement procedure. The first hierarchy that comes when you file it with SEBI, the first committee that takes up your matter is called as internal committee. This is constituted by SEBI only. It comprises of the SEBI, officers of SEBI not below the rank of chief general manager and such other officers as specified by the board. Do we have to remember this? No. But remember, they are the first point of contact in SEBI when you are filing settlement application. They are called as internal committee. And how does our procedure go? Internal committee will first scrutinize. They will question you. If they are okay, then the matter will go to the next authority. The next authority is called as HPAC, High Powered Advisory Committee. Now, what is High Powered Advisory Committee? See, it is again constituted by SEBI for recommendation of terms of settlement. So, what do you mean by that? Whenever an application comes, this committee will be formed. But of course, people, in a country like India, every day you will be getting. So, we have a High Powered Advisory Committee which is already set up. But can it change with case to case? Answer is yes. With case to case, the answer can change. There is something we need to see here. I will tell you after a certain procedure is done. What is that? Clear? Okay. Next one, composition, sir. A judicial member will sit. Judicial member means people. Always it will be a person of High Court, Supreme Court. That judge only will be there. Next one, people to assist him. That is what is called technical members. 3 external experts in securities market. Why? Judicial member has a generic experience. Technical members will have a specific experience. Both are required. Are you getting the point? Okay. Tenure, sir, the term shall be 3 years and you can extend it for another 2 years. Quorum, sir, the meeting shall have minimum 3 members. Is this clear, all of you? Okay, done. Sir, now once they agree, people, the last it will go to panel of whole time members. Now, if whole time members also agree, people, now only settlement goes ahead. Sir, and remember, settlement can be cancelled at any stage. IC could have approved, HPAC will reject. HPAC could have approved, whole time members will reject. Anywhere it is allowed, it is possible. And remember, at any given point of time, the application can be sent back to the first stage. The whole time members can feel, no, the way we have handled this dispute is not up to the mark. You have to reconsider the entire issue. You have to come back from the beginning. You will again repeat from IC. Now, is it expressly written? The answer is no. But if you understand this, now you will understand the further procedure. Are you getting it? If not, how we will be seeing? They will be writing it as IC have approved the settlement. HPAC has rejected it. We will not understand, ayo, if IC has approved means settlement should go through, no, why HPAC is coming? This is how the structure is made. Clear? Yes, sir. Okay. Regulation 12, 11, done? Okay, now go back to that chart. What do they say? We have seen regulation 5, regulation 6, regulation 4. We saw internal committee as well. Correct? Now, what will internal committee do? Internal committee may call for documents or information. You have filed an application. They have some problem. They will ask for further information. You have to give. That is your duty. Call for personal appearance if required. All of this is still going on. Applications. If I think you have to personally come, I will call you personally. You can go or you can send a authorized representative. Comply with condition precedent. What is condition precedent? Disgorgement, settling of the clients, don't have any outstanding money, wash off everything and then come here. Next one, submit revised settlement terms within 15 working days. What do you mean by that? You have come and you have given. I am not okay with it. Come back with another thing. So submit another plan. So within 15 days, people, I can tell you to come with a revised settlement terms. Whatever you have given, we are not okay with it. Come with a revised term. That can also be possible. Within 15 days, you have to come with a revised settlement plan. Is this part clear? Yes, sir. Okay. There is this note, which is nothing but regulation 7. What does it say? See here. Sir, we have filed an application for settlement of proceedings. Can we take it back? The company, can it withdraw? Answer is yes. You can withdraw until it is in any particular, with any particular committee, whether it is with internal committee, whether it is with HPAC, or whether it is with the whole time members, until the order is passed. You can withdraw your application, but remember, if you want to again apply people, then there are some requirements you need to understand. What is that? See here. An application can be withdrawn any time prior to the communication of decision by the final panel of whole time members. Once withdrawn, cannot file again for the same default. However, sir, please, we withdrew because of some reason, sir. Can you please again take it back? It can be taken back, people, provided you need to first apply with HPAC. If HPAC is satisfied, we can again take it. We will take it, but remember, the settlement amount will directly go up by 50%. If we had agreed for the settlement as 6 crore, 10 crore, now we will levy 15 crore as what is the settlement proceedings. Yes, that is what is given here. It may be allowed on recommendation by HPAC. Any doubts here? Is this part clear? Clear? Okay, done. Now, IC has approved it. IC, internal committee has approved it. Now, where is it coming? It is coming to HPAC. See here, proposed settlement terms shall be placed before our HPAC. Now, what will HPAC do? HPAC may consider settlement terms, plus it can even say, hey, this is okay, I am not happy with it. I can even revise it further. That is also possible. So, when this comes, read regulation 9 and 10. Go back. See where is 9 and 10. This we have seen. What is 8? Will come back. Wait. Now, settlement terms. The settlement terms may include a settlement amount or non-monetary terms. people, so whatever is a settlement, people, settlement can happen two ways. One is monetary, one is non-monetary. Monetary means people, money is involved. Non-monetary means what, people? Submission of your, now say for example, you are continuing as a investment banker or investment advisor, but you are not following the terms and conditions of the license given to you. I can take back the license, that will come under non-monetary. I can issue a suspension for 1 year. That has nothing to do with money, that comes under non-monetary. So settlement can have two things involved. One is money related, one is non-money related as well. Both can be involved. Yeah. Now see what they say. The non-monetary terms may include the following: suspension or cessation. Simple, huh? Second one, exit from the management. That director has to resign from immediate effect. Second one. Third one, disgorgement on account of the action or inaction of the applicant. Disgorgement means, people, whatever is the money, that has to be repaid. Fourth one, refraining from acting as a partner, officer or director. Come down. No partner, give it away. Cancel securities and reduce holdings where the securities are issued fraudulently. What do you mean by that? Sir, in the case of Sahara, we are saying 2.5 crore worth of debentures were issued. But how? That entire issue is bogus. Cancel that entire securities. You just tear it, that's all, done. And not only that, sir, reimburse any dividends received. Meaning, people, on 2.5 crore, you have been paying interest, dividends, then whom are you paying? Take back the entire money. Yeah, you will not believe, people, there is a company called as Satyam. In Satyam, he has done every scam, people. Whatever inflation of sales, all of that. And he has done one more scam, you know what? Now, people were telling that he has purchased land in Hyderabad. Why? Because he had a plan of where the metro was coming. The complete plan of metro. Even before it was available in the public domain, he already has the access of it. Now it is not a rocket science. Wherever the metro station comes, around that, the real estate will definitely boom. Agreed or not? Now what this person started doing, he started accumulating assets in and around that metro station. Yeah, with the thought that it will go up. But see, that's why they say fate has to favor you. When all this was happening, it was a time of 2007-2008. 2008, recession hit India very hard. Just like now what Trump has done. All over jobs were going back. Now when jobs are going back, COVID, when people are losing jobs, do you really think people will invest in real estate? People were going back to their home, for different places. Bangalore real estate was crazily down. Crazily down. Today, if a rent costs you around 20k, during that time, the rent was costing you 8k. Are you getting it? Now, Satyam purchased, that entire person, his name is called Ramalinga Raju. He purchased the land when it was 1 crore. When recession happened, no one is ready to buy the land. So 1 crore is becoming 80 lakh, 60 lakh. His thought was, I will manipulate it. Land price will go up. I will sell it at a higher price. Whatever inflation I am showing in my sales, I'll take that money, I'll put it here. So that no one will know nothing has happened. In fact, he has written one apology letter. He has only admitted everything he has done with SEBI, with the letter. It is there in public domain also. In that letter he has written, I was aware and my life was like I was riding on a tiger. For the world, I am riding on a tiger. But I was riding on a tiger which I was aware that the tiger will bite me someday. It will eat me someday. I was aware of it. So I took the cushion of tiger, I know. But I know I could not survive it any longer. What did he try to do? He tried to manage the non-compliance. See, now I have inflated. My sales is 7,000 crore I am showing. In the bank account, 7,000 crore is not there. How do I get it? by doing all of this. Now this also gone, that also gone. That is the day where he came and he admitted, he wrote a letter addressing to SEBI. Now if you guys find time, read it, all of that. Very nicely it is written. See. Understood confidentiality treatment. If confidentiality treatment is given, this will not be available in public domain. But everything will be settled and done. We will not know. World will not know about it at all. That is called as confidentiality treatment. Understood? See, I've inflated non-existent cash and bank balances of 5,040 crore. Macha, year seeda. Today, what is the value of that 5,000 crore? See here, an accrued interest of 370 crore, which is not there at all. But in my books, I'm showing that there is 370 crores. See, an understated liability, meaning what? The total liability on the company is 1,230 crore. But how much we have shown? Okay, no. He is saying I have understated the liability by 1,230 crore. Meaning what? The total figure is 5,000 crore. They are showing 3,800 crore in the book. 1,200 crore liability itself is not shown. And overstated debtors. 490 crores. I'm saying, sir, we need to get money. We will get it someday. See, people. See. Complete letter. Somewhere if you do Control F, you will get the tiger also. See, the aborted Mathis acquisition deal. Mathis, you know what it is? So what did he do? He opened one real estate company which purchased all these plots. So the thing was, if the real estate goes up, that company will give back the money to Satyam, everything is done. But real estate fell. The last thing he tried was, Satyam will acquire this real estate company called as Mathis under him, under Satyam companies. That will become subsidiary. And we have to give consideration to purchase. He proposed a consideration of around 8,000 crores to take over that company. That time the board said, what are you guys doing? Are you mad? What company is this? Why are we offering 8,000 crore? His thought was, if I show in book 8,000 crore, it is me only here who receives it. So to the world, I will set off that 8,000 crore. That I have received it, I will show as if I have received it, and we can set it off. In fact, Mathis is nothing but people, you can see, it is a reverse of Satyam. Maytas, Satyam. It is his company only. All the doors were blocked. Yes, see. I am now prepared to subject myself to the laws of the land and face consequences thereof. Finally, he admitted what else he could do. Imprisonment, disgorgement order, all the assets were taken back. SEBI has imposed penalty. Securities Exchange Commission, US Stock Exchange Regulator, they have only imposed a penalty of around $9 million. $9 million is how much? 90 lakh dollars. 90 lakh into 100. Around, he paid good suspension. People, can you see this? Every attempt made. Read that. Every attempt made to eliminate the gap failed. As the promoter held a small percentage of equity, the concern was that poor performance would result in a takeover. So in Satyam, he was holding only 2%, 3%. His fear was someone will come and acquire of the company. To avoid that, what did he do? He started projecting the company sales very high so that no one in the market can acquire them. Okay. It was like riding a tiger, not knowing how to get off without being eaten. So he went on it. It is nice, but I cannot get down also because it will eat him. And I have to continue riding it, knowing that it is unsafe. Nice, no? We learned one good English sentence today. That is what it is. See, this is Satyam's thing. Yep. What a fair idea. Where can we get? Search it, you'll get it. It is there on public domain. Got it, huh? So all these, see, he has said so many. Those things will come under non-monetary, no? Resignation and all that is non-monetary. Okay. Lock in. One more thing, one more thing. One more thing he has done is people. Now few people ask that question. So you are saying he has purchased so much of land. For that at least he needs money. And in company that money never existed. They have just inflated. So it is just book entries. Now where did he get money to acquire this land? So people, in Satyam's payroll, around 8,000 employees were dummy employees. The money was being credited to this bank accounts every month as salaries, which was drawn by Satyam, that is Ramalinga Raju, in the back end. 8,000 employees' ka salary was his consolidated fund. Technically, that 8,000 employees never existed. இப்படி அண்ணா அண்ணா சும்மா அதிருது இல்ல. You guys can't think of he has violated all that. It was a listed company da. You know one thing, in 2008 all this happened. That is around September. In 2008 May, the New York Stock Exchange gave him a Golden Peacock Award. That is given to a person who is compliant with all the laws. The best compliant company will get Golden Peacock Award. See, Anna got Peacock also. எப்படி? Who were the auditors? The main people. I told you, know why this entire provision of rotation came. If you ask me, biggest reason is this people only. Biggest reason. If they were someone from US and all, no, you know Big Four? They call Big Four, no? What do you mean by Big Four? Deloitte, KPMG, EY. Fourth one is PwC only. We are still respecting them. And whether you know it or not, people, in 2001, we technically had something called as Big Five. Big Five has become Big Four. Now, where is the fifth person? The fifth person was the first person amongst the five, the topmost in the top five audit firms of the world. Big Four is Big Four of the world, not of India. It was actually Big Five. Who was the topmost? The top person is called as Arthur Andersen. That's the firm. They were the auditors of Enron scandal. The biggest scandal that we have seen. Satyam scandal is a remake of Enron scandal. But he did it in reality, not as a movie. So cut, copy, paste. Anna, whatever he did, he came and he applied. He also got caught. Here PwC, there Arthur Andersen. But there, because they were based out of US, the Securities Exchange Commission slapped them so hard they could never recover. They ended up in a dissolution. India, no, it'll chalta hai. Yes, it's called Arthur Anderson. Where is it? Here on it near Hebbald. Hey, I told you they're liquidated. Again, you're doing where are they? They're liquidated. Kanna. Okay, understood. See, you should know all of this. Some history will be there. It'll be mystery. Lesser Companies Act. Okay, now read. Implementation of enhanced policies and procedures to prevent how to know. Hey, you have something called as ChatGPT. Just type the top 10 interesting cases in India with regards to whatever you want, you read. It will literally give you all the information. I'll tell you one thing, if you guys get time, there's a case called as Titu Singh case. It's called as Titu Singh. Titu. Tittu. Titu Singh's case. Watch it. Come and thank me tomorrow. Today's your suspense thriller is taken care. Crazy case. Hey, movie it is. Real life movie. Trust me, goosebumps, you'll get goosebumps. If I narrate also, you'll get goosebumps. Like that the case is. Oh, no. First only that they are telling us, sir, tomorrow is the last day. I am in 7th chapter. Narrate, sir. You tell that. You tell Kantara. If you know Kantara 3 story, also tell that also. You tell that. Okay. Implementation of enhanced policies prevent future security law violations as the case may be. Provide enhanced training and education to the employees of intermediaries wherever they are going wrong. Submit to enhanced internal audit, PwC, Anna Bond. This is where everything went wrong. They were not the statutory auditors, they were the internal auditors. Restraining from accessing the securities market. Suspension. That is what the first one, no? Legal cost, this we will come back and see. I'll come and tell you what is that. Amount of profits made, okay. Now, regulation 10, factors to be considered to arrive at the settlement terms. Now, how will they say that you need to pay this much, this much? What are the factors considered? First one, conduct of the applicant. How are you when the hearing is going on? Sir, like this. Are you, sir? Like this. Now, good for you, good person. Da. See, very good character and all. Then, okay, less penalty to him. Yeah. Or imagine, kya re? If you are like that, penalty is more. The role played by the applicant in case the alleged default. Role played means what, people? Did you help or we only figured out? Difference is there, no? If you have played a role, then we will give you the benefit. Third one, nature, gravity and impact. Nature, serious, less serious. Gravity, penalty, whatever you did, does it, meaning like investor grievances? Have you cheated investors? So whom? What is the entire thing about? And impact of it. So that will be considered. Whether any other proceedings against the applicant, meaning only this or any other thing is there, consider. The extent of harm, people, unlike company law, compounding, we saw the case, no, that Vishwanath case, Kerala, where if a compounding order is passed, you cannot, whether the authorities or the person cannot reopen the scenario. We saw that, no, that is not the case here. Imagine settlement order, SEBI macha has covered everything. They will know everything, I'll tell you. Imagine settlement order is passed. It's done and dusted. After 1 year, SEBI when casually they go for a morning walk. They get to know people, there is some missing information in the case you have settled. SEBI can reopen the issue, they can reinitiate the proceedings. The fun part is, whatever you guys have paid as settlement amount will not even be refunded. The proceedings can initiate from the beginning. Yes, settlement of administrative offences could have been done. Even after that, the case will start, and the money also you will not get. It's non-refundable. You know what? You have in Google Pay and all, you have that referral, no? Macha, take my code, I'll get 100 rupees. You guys have done, na? No, Rich people you are all. We have all done. Initially, when Ola, Uber and all came, you don't know how we were. We were part of that first generation when Ola, Uber was coming, 2013-14. You'll not believe people. Now also, if I think, I will feel how much we have exploited. People, you'll not believe. We were staying in one room. Ola, Uber was new. It's like, Macha, if you refer, you will get 100 rupees it seems. That time, how much tariff? You can go from here to 7 kilometers in 100 rupees. It was not surge, this 2 times, this tip culture, nothing was there. Now what we used to do, I will refer you how many phone numbers we have. So, the Just Sandwich is there, no? That coffee shop, I'm not even exaggerating. From here, how much that is 50 meters, People, we have booked cabs. Free. We have exploited Ola Uber. 50 meters. First initially, my Ola referral balance was around 1,300, 1,500. My Kandan, my relatives in home, in native, installed, I'll get 100 rupees. Today it is there in every place. Huh?
We have done this with Zepto Free Cash.
Zepto. You do it, no? Then that's what I'm saying. Ola Uber, we exploited. Yes? You know, this concept came from SEBI. In SEBI, there is something called as rewardal scheme. Now, Mehna goes and says everything about what we did. Imagine I said, sir is giving all trade, sir, you have to catch him. Now, people, SEBI will file a case on me. If it ends up in a default, SEBI ends up getting money. How much? Let us imagine SEBI charged some 1 crore. Mehna will get 10% of whatever I pay. 10 lakh is Mehna's income. That is, yes, that is there. We have both type of schemes. If you want your identity not to be disclosed, that is also maintainable. Mehna is like, she's closing the pen and say, sir, why sir, all this 10 lakh, every day I'll give her 2 complaints. Easy sir, idella why sir? Simply settlement order and all. Yes, no. What will the SEBI do from all that fine and penalties they collect? SEBI also has to run, Noda. You guys would have studied investor protection fund, investor education. How will investors get educated? Money is required, no. They will spend on all of that. Some will go, some will not go. Some will go to the fund maintained by central government. And SEBI maintains one fund also called as IPEF. Don't get confused. Companies Act is IPF. That's why I say it is the Investor Protection Education Fund. It's a different fund which is maintained as per SEBI. Now you are saying where will it go? Satyam case, or let us imagine Harshad Mehta case, 6,000 rupees dumped to 300. They have all suffered. They will file a class action suit. Such money can be used to pay their legal expenses. Whatever we can help you to recover, those things will come here. Clear?
If any compounding is done under Companies Act, then we should not revisit.
Hmm.
But if after some period, we are saying that they have contravened laws as per SEBI. Now SEBI can reopen.
Possible. That is possible. As long as SEBI has jurisdiction over it. If you remember, even yesterday also, when we were seeing who can file an application, we saw if it is with regards to share transfer and dividends, SEBI will also have a right to file an application. That was with regards to that only. SEBI will also be one of the authority. They have a power. Here, okay. The process that have been introduced since alleged default to minimize future defaults or lapses. Okay, compliance schedule proposed by the applicant. Compliance schedule means what, people? I'll give you one timeline. By this day you have to give this. By this day you have to pay this. You have to follow that. Economic benefits accruing to any person from the non-compliance or delayed compliance. So I'll consider all of these people while I'm passing settlement order. Conditions which are necessary to deter future non-compliance by the same or another person, meaning the way I decide this, it will have an impact on the future compliances. I will pass, I'll keep that in mind. Satisfaction of claim of investors regarding payment of money due to them or delivery of securities to them. Imagine you have made a non-compliance. If you have complied with all of that now, you should have paid money to the people. Now you have paid money also. Then I'm happy. I will treat your settlement application accordingly. Any other enforcement action that has been taken against the applicant for the same violation, meaning what people? Not only me, right? There are other. Now I told you PwC, Securities Exchange Commission is also taking action against them. I'll keep that also in mind. Any other factors necessary in the facts and circumstance of the case, I'll keep all these things in mind when I'm deciding the penalty. Is this clear, all of you? Yes? Okay. Give that a read. All generic things they have given you, but try to understand. The factors is given in Regulation 10. Next one, undertakings and waivers. Undertakings is nothing but promises. I will not do it again. I'll not take up any listed company's client again. All those things. It may seek revision of settlement terms and refer application back to internal committee. I told you, every person has a power to send the application back to stage 1. Like HPAC here can say, we are seeing HPAC only, no? I can tell, go back and come from the beginning. Start from the beginning. I have a right to say that. Are you getting the point? Okay. Now, sir, recommendation of HPFC shall be placed. Now, in HPAC, what is happening? Try to read this. See if you guys are understanding. The high-powered advisory committee shall conduct its meetings in the manner specified by the board, provided that. So now people, the matter has come to HPAC for settlement. Now there is a judicial member, there are technical members. Now how do we take the meeting ahead? Now let us imagine if two people are saying okay, two people are saying no. Two people are saying let us settle, two people are saying let us not settle. Or let us imagine the judicial member, whoever is a judge. Now on whosoever the case is coming, that person is my relative only. How do I see this dispute? In such case, what do we do? I don't know if you guys know. Recently, there was this that Hindenburg's report. You guys know about Adani. You know this Kantara? Kantara. Hey, something you should know, Noda. Global news, though, all these are. Hindenburg is you can imagine like this people, a research firm. If Hindenburg types any company's name, forget about anything. Imagine Hindenburg's today types Infosys. Infosys shares will crash. I'm not even saying I'm saying I don't know. I'm just typing Infosys. The company will crash. That's the power of Hindenburg. Recently, Hindenburg has come and said that I started this firm with a different intention, but more than good, bad is happening to the people. Because people would have invested. These people will do research and they will say that this company is screwed up. They act like a private agencies. They will analyze the financial statements to the core and they will say this company is not looking good, look into it. So once they report, our regulatory bodies in that country, they will take an action based upon that report. He looks into every company around the country, around the world. One day, one fine day, Anna Bond typed Adani. Fell. Adani literally went to ground floor. But 10 days happened, 20 days happened, 30 days happened. SEBI did not take any action. SEBI did not take any action. And this was also highlighted by a lot of people. Why? Someone is giving a speculation and someone is clearly giving it by data. See this, see this, see this. What do you say? people literally started pointing out, Ano. Huh? What are you guys doing, da? SEBI, da? The biggest regulator of the country, the chairperson's daughter has been married to Adani, Gautam Adani's son. The MD of Adani, his son is married to chairperson of SEBI. Tom. Huh? I don't know, I'm just giving you facts. I don't know what happened. This is the facts. You can see, the moment I touch this, Gautam Adani, SEBI chairperson, this should come, no? Why this is coming? Report, see da, Hindenburg report. It did not go forward at all. Something fishy, no? So what happened and all? You guys do your research. Sir, tell more cases like this, sir. This subject you leave, sir, it's okay. They concentrate da. Now see what he has written here. In such case, what should they do? Sir, daughter, sir, that is my father-in-law, sir. What do I do? I'll become a judicial member. Can I decide that case? You need to recuse yourself. It's called recusal. What do you mean recusal? Macha, you have to step down for that case. Understood? So, where any member of the high-powered advisory committee seeks recusal, then in such case, what do we do? The remaining 2 or more members may submit their recommendation for the settlement. Getting it? The committee's quorum should be 3. But if one person is interested, conflict of interest, what do? You step down. 2 or more, they will give their approval. That is how the settlement will go. Next one. Where no consensus or majority may be reached. Sir, we are 4. 2 are saying yes, 2 are saying no. What do? The recommendation made by the important person will go through. One is technical, one is judicial. Technically, one is the judge. Supreme Court, High Court, Chief Justice is. So whatever he says will go through. Sir, what if, like SEBI, the chairperson, meaning the main person only, sir, father-in-law, what do? You have to recuse yourself. Yes, sir. Now, in such case, what do? We will go with majority. Whatever the other people are, if the 2 people or more are there, we will go with the technical members' approval. Sir, let us imagine, sir, all the entire committee is family members. Everyone are interested. Now what to do? Then Macha, SEBI will replace the entire committee. That is the last one. Understood? Mena is like, sir, all this can happen, sir, even in SEBI levels. Shock, no? That's why you need to read news and all that. These are all good news. At least not boring news. Good only it is. You can read all what is that? Surprises, shocks, everything will be there. Yeah. Okay. Now till here is clear, Now HPAC, let us imagine they have passed their order. Now where it will go? The third committee in SEBI only. So if you do not know that chain, see, you'll be feeling, sir, what is happening? Sir, in SEBI only the circular, it is going circular, oh, sir. Where does it go forward? That is why it is all within the committees. That's where I say you need to know the background. Recommendation of HPAC shall be placed before the panel of whole-time members. Okay. Now it may, Papa, they have come from there to here. Directly I can still reject it. I am not bound by whatever HPAC says. Seek modification. They have kept as 3 crore. I will put as 5 crore. I can enhance it. That is allowed. Panel may return application for re-examination also. Go back and come down. In such case, procedure as applicable in case of original application shall be followed. Meaning people, again IC, again HPAC, then come to me. The last one, accept. The application shall be issued a notice of demand within 7 working days. Applicant to remit the settlement amount in 30 calendar days. Fulfill other settlement terms, meaning non-monetary. That is suspension, giving away the clients, giving the details, all that also has to be covered. Is this clear? Yes, sir. Okay, that is the procedure. That is what they said. They can settle, they can reject. The panel of whole time members, 7 working days. Re-examination possible, done. Understood? Yes, sir. Sir, now I have a doubt, sir. Sir, let us imagine the non-compliance is clear. SEBI only caught you. SEBI can literally give you an option, Macha, I caught you. I'm not even asking. I know you have done a default. It is very clear how you are doing these things. Now, for example, you are present on YouTube. You are not registered with us as a finfluencer, but you are present. You are giving the calls. Now, it's a clear non-compliance. Now, do you still want to go through the entire route? IC, HPAC, whole time members. You want all that, That is, people, it is happening as a settlement. Meaning, I will listen, you will listen, all that will happen. I'll best tell you, admit of the mistake. I'll tell you what amount to pay and be done with it. Is it, sir, best suiting for you? Best time will save. That is only called as people summary settlement. When SEBI issues the notice itself, they will tell you, don't go under a lengthy process. I'm telling you, your case is best suited here. You will have to pay penalty. No doubt, you can't escape. If that is the case, you also surrender. Don't go for negotiation. Settlement is negotiation. That's why you are submitting your plan. Here, nothing doing. Of course, you have a one thing for rectification, but apart from that, you have nothing. The simplest is called a summary. That is correct. I'll tell you, not every default summary is possible. Summary is possible for a certain defaults. That is what is given in regulation 16. What is that? See here. Notwithstanding anything, before initiating any specified proceedings, the board only may issue a notice of summary settlement in the format. Calling upon the notee, meaning the person to whom we are issuing, to file a settlement application. Hey, come and file it off and be done with it. The summary settlement notice in respect of the specified proceedings to be initiated for the following defaults. So for what and all we can do summary settlement, important, they can ask you a question. First one, delayed disclosure. Simple. You should have done it within 30 days. You have not done. Clear non-compliance. First one. Second one, non-disclosure relating to companies exclusively listed on regional stock exchange. Delayed disclosure. You should have filed within 30 days. You filed it in 60 days. Non-disclosure. You should have filed in 30 days. You never filed at all. Both are non-compliance only, no? Third one, disclosures not made in specified formats. I've clearly told you to give it in format 1, format 2. You did not disclose in that. Delayed compliance of any of the requirements of law or directions issued by compliance. Delayed compliance means, people, I should have followed a particular procedure. I did not follow it. Fifth one, such other defaults as may be determined by the board. Now, in these 5 cases, people, I can go for a summary settlement. Okay. Now, what does it say? Provided that the specified proceeding shall not be settled if in the opinion of the board, the applicant has failed to make a full disclosure. I have told you, if you do not make a full disclosure, summary will not happen. We will leave this here. Now, the notee may, within 30 calendar days from the date of receipt of the settlement order issued by SEBI, file a settlement application. I will say, sir, I will file. And remit the settlement amount as specified in the notice of settlement. Whatever is the money, you send it. Comply with the non-monetary terms, suspension and all of that, comply with it. Seek rectification of calculation, if any. This is the only thing you will have. What is that? SEBI has said, you have done that, for that you need to pay 1.5 crore. You have done this, for that you need to pay 25 lakhs. So together you need to pay 2 crore. Please pay within 30 days. Sir, now I will say, sir, I will pay whatever you said, sir. But 1.5 plus 25 lakhs, sir, will come to 1.75, sir. But you have mentioned it as 2 crores, sir. Please rectify that. That alone is allowed. That is why rectification of calculation alone is admissible. Yes, sir. And you need to remit the money within 30 calendar days. That is clear, all of you? Provided that if the SEBI wants, if it is justified, we can give you an extension of 15 days. Okay. Upon being satisfied with the remittance of settlement amount and undertaking furnished in respect of non-monetary terms, if any, as detailed in settlement notice, the board shall pass an order of settlement. Considering all others, I will pass an order of settlement. Next one. Okay, what does it say? Regulation 17, notwithstanding anything, all these try to remember as summary. Regulation 17, notwithstanding anything contained in these regulations where a notee does not file a settlement application or remit the settlement amount or comply with non-monetary terms to the satisfaction of the board or withdraws the settlement application at any time prior to the communication of decision of the board, the specified proceedings may be initiated and such a notice shall only be permitted to file a settlement application in respect to the proceedings pending before the court or tribunal after the conclusion of proceedings. What is that, sir? I gave you a choice. You did not go ahead. SEBI will start the proceeding against you and the whatever. Now imagine if SAT is taking it up. Special court is taking up the matter. Now they will take up the matter. I will not give anything for your hearing. You cannot come up after I initiated. So time period will be given. If not within time period, people, then I will go ahead with the initiation of proceedings. Next one, sir. Settlement with confidentiality. I'll tell you what is this. Okay, let us do one thing. You guys go for a 5 minutes break, go back and come, and then we'll do some 2 parts and we'll be done with it. Yeah, take 5 minutes break and come. Yes, now we will. As I told you, whenever you are filing for settlement of your proceedings, now whatever is the information I have filed, now SEBI will also pass an order. Should all that be visible in the public domain? Do you want your name to come in the public domain? You can go and ask SEBI ji, please choto. So if SEBI is convinced, then SEBI will exclude your name from being added and you will be getting a confidentiality treatment. Now, when will you get that confidentiality treatment or when will it be taken back? The confidentiality treatment will be given. Try to remember this. The confidentiality treatment will be given whenever I'm satisfied, you're satisfying these consideration, these points. What is that? You cease to participate in the violation. You were doing, now you are no longer doing. I'm happy. Second one, provide and continue to provide complete and true disclosures. So when you're disclosing, when you're giving the evidences, don't hide half and give the other half. Give completely. If I'm satisfied, I'll give you confidentiality treatment. Third one, cooperate fully, continuously. I'll be asking you for proceedings. I'll tell you to come. I'll tell you to get me the documents. Wherever possible, you have to cooperate. Fourth one, not conceal, destroy, manipulate, or even remove any relevant documents from my records. I'm destroying something. That's what. If at all you're doing all that, then no confidentiality. If you're doing all of those people, then SEBI will extend you confidentiality. Now, what do you mean by confidentiality, sir? At any stage, if at all it is found that you're not complying with it, I can reject the treatment. Okay. This is important. Notwithstanding anything contained, the following shall be treated as confidential. What I say as confidential? First one, your identity. World will not know whom we levied this penalty against. Penalty will be there. Whom we wouldn't disclose. Second one, the information, documents, and evidence. So I'm giving you the documents, I'm giving you the evidence, I've given you so many proofs, bank statements, nothing will be coming in public domain. Furnished by the applicant under this chapter will not come under public domain. It will be treated as confidential. However, the confidentiality can be broken in these three scenarios when the disclosure is required to be made by law. Imagine on you a money laundering case has been filed. People will go and ask SEBI, do you know anything about this person? SEBI will have to cooperate. Second thing, the applicant has agreed to such disclosure in writing. I have only agreed, it's okay, you give, you can give. The third thing, there has been a public disclosure by the applicant. You only put on your company's website. Imagine Infosys has gone for a payment of settlement of proceedings. They have done. As a good corporate governance, they have disclosed it in their corporate governance report. Now, when you have done it, SEBI can do it. Clear? This part, they can ask you this, so remember and go. Next one. They can give an interim report. That is okay. That is, I can give you an assurance that you first give me, I will treat it as confidential, but I can take it back also. That is okay. You can ignore this as well. The last one, settlement order. Now everything kept in mind, people. Final settlement order will be done. You will have to comply with the settlement order as per the terms given in the order. Once you comply with it, the settlement proceedings will come to an end. Shall dispose of the respective proceedings by an appropriate order on the basis of the approved settlement terms. Meaning, if proceedings have started, if you have paid everything, everything is done, we will make sure the proceedings come to an end. If at all the proceedings have started in front of any tribunal or any court, of course it will come to an end after you pay the settlement amount. Okay, simple. Service and publication of settlement order. Settlement orders shall be served to the applicant, whoever he has, will give it to him, and also published on the website of the board. Of course, keeping in mind the confidentiality treatment. Settlement schemes. Any idea of what are settlement schemes? What do you mean by settlement scheme? Any idea? Once in a while, see, this is only for you. Once in a while, let us imagine this black money, white money is there. Now, what do you mean by black money? On that which tax is not paid is called as black money. Once in a while, government itself will come and give you a scheme. That is, guys, file the tax. I will not ask you the source. You pay the tax, it becomes legal money. At least once in 4 years, IT department will give you that order. Last time they gave was in 2023. And IT department collected around 60,000 crore as tax because of that scheme. And in that they say, we promise, we will never question you about the source. See, anyways, you will not tell, it is hiding. At least by doing this, 60,000 crore is collected. It's not a small amount. So that is only called as settlement schemes. If I think that there is something like this happening, SEBI can come and give it as a scheme only. You come down, whoever has done that non-compliance, come, I will not question you. Just pay the money and be done with it. I have a right to give that. That is what is Regulation 26 saying. In general, I can introduce it as a scheme only. Anyone who has done this dispute can come and settle the matter. I am allowing it. In company law also in 2021, there was a scheme that they introduced. You can make good whatever defaults has happened. Even if time periods have passed, you can make good the default. 2021, there was a scheme. I forgot it, CLDSS or something. Some scheme was there. Sir, effect of settlement order on third party. What is this? People, imagine I settled it with a person. A person filed that, sir, I have done a non-compliance. SEBI has issued a settlement order. Anyone else cannot take it as a evidence in their proceedings. What do you mean by that, sir? Let us imagine, people, there is a case going on. ABC versus SEBI. They are fighting in the court. XYZ and SEBI have in the past, on the same grounds, they have settled a matter. ABC cannot quote this as an evidence in the further proceedings. Whatever happens in this issue, it only stays with this issue. It does not act as a precedent. Sir, we didn't understand. In law, you use a word called as Landmark judgment noda. You give it as a precedent, no. It cannot be referred as a cross reference. It is only for this. It cannot be used as an evidence in any other case. Is this clear, this part? People, and see here. Revocation. What is revocation? Macha, whenever any settlement order is revoked, no amount paid under these regulations shall be refunded. First thing, if the applicant fails to comply with the settlement order at any time, even after the settlement order is passed, it comes to the notice of the board that the applicant has not made full and true disclosure or has violated the undertakings or waiver, settlement order shall stand revoked and withdrawn, and the board shall restore or initiate the proceedings. And sir, what about the money I paid? Everything is gone. It is not refundable. Is this clear? Hello? Confidentiality is what we saw. This is the case what I was telling you people. This person was doing the service of investment advisor but without getting registered. SEBI filed a case, Macha, you have done a heavy non-compliance, better you only agree. He agreed. They agreed for a settlement. The settlement terms was this. See here. Settlement amount of 15,60,000 rupees to be paid each. That is, there were 3 people, I believe. So they had to pay 46,80,000 rupees as a settlement. Okay. Disgorgement. You would have taken fees and all, no? Look at the disgorgement. 6 crore. 6 what? 6 crore 7,69,000. People, you have taken from 10 years. Were you allowed to take? No. Then pay interest. 12% rate of interest. Yes, sir. And not only that, the applicant shall refrain from buying, selling from for a period of 1 year. Nothing but suspension. Interest will go to the people because my money was blocked with you, no? Yes, sir. That is what was this scenario. Last one, people, is Competition Act. Tomorrow we'll do FEMA and Mediation and Conciliation. Simple, people, you guys would have done, actually you have done everything in ECI bill only. If any order is passed by CCI, the CCI, whatever is the appellant authority, the cases will go to NCLT. Appellate body for NCLT is NCLAT. That's all. That is what is given here. Competition Commission of India, appellate body will be NCLT and NCLAT. Clear? Yes, sir. I think we can end up here. Yeah. So tomorrow again we'll have the class in the morning only. We'll finish it. We'll see whatever is the best we can finish. We'll finish it. Yes. No, I have class till 19th. So Sunday also I'll take. I'll make sure I'll trouble your Sundays also. Because that's the last day, no? My wife gave an warning, you better come home on Sunday. But I cannot. Because last day we have to take. At least something, whatever is possible, we'll finish. If not, we'll now again fall in the loop. Yeah. Okay, people. So let's catch up on tomorrow.